I don't think it's necessary to repeat that.
Thank you.
Good morning, Your Honors. May it please the Court. Kurt Da Silva, legal officer for the Guyana Elections Commission, appearing for the Chief Election Officer.
I think we have not gone through our list yet.
May it please Your Honors, I am Ganesh Shira, and I appear for Vishnu Bandhu, the representative of the United Republican Party in the Consolidated Appeals.
Please, Your Honors, Kamal Rampuran, holding for Timothy Jonas, Senior Counsel, for Asha Kisoon, representing the New Movement, and appearing on my own for Jonathan Yearwood, representing a New and United Guyana.
May it please Your Honors, should it please this Honorable Court, I, Kailash Lokman, appear along with Mr. Kashir Khan, Mr. Ivan Alert, Mr. Mohammed Khan, and Mr. Joshua Abdul on behalf of Shazam Ali, representative of the Citizenship Initiative.
And someone appearing for Mr. David Granger.
Your Honors, I have already entered appearance for Mr. David Granger as the fourth name respondent. And I could do so again. Bassett Williams, Senior Counsel for Mr. David Granger, representative of the Partnership for National Unity and Alliance for Change.
Yes, thank you very much.
Thank you.
Counsel, before we get into the matter itself, there is a matter of order that we have to discuss. The order of the court made it clear that written submissions had, if submitted, had to be submitted before a certain date. Written submissions that were filed by Mr. Khan on behalf of Ali was late, and that there was no application for an extension of time or anything of that sort. We saw some email from the respondents that they had a problem with that, but we have not seen anything official. So let's clear that point from the start, what the position is. Mr. Khan.
Good morning, Your Honors. Are you hearing me?
Yes.
Your Honors, unfortunately, I seem to have a challenge. I got bounced and then my camera is not working, so I apologize for the fact that you're not seeing me at the moment. Your Honor, as it relates to the submissions were in fact submitted not in accordance with the order of the court, and I crave the court's indulgence to accept it. We had some technical difficulties which I was not able to overcome within the stipulated period. I did make contact with the deputy registrar, and it necessitated essentially redoing the submissions in order to make to have it uploaded.
But normally, if one is late, when one can apply for some extension of time, but you didn't do that.
No, please, Your Honor, we did not, and we are at fault where that is concerned.
Okay, anyone who wants to say something on that point? Respondents?
I'm sorry, Chair, but I wonder if we have to go that far. I don't know if Mr. Khan is now making an application, is he?
I am, Your Honor, in accordance with part 14.4. I'm seeking leave of the court to accept the submissions.
Okay.
Yes, but because there was a problem with that expressed by the first and the second respondent, I would want to know what they think about that. Is there any objection?
Yes. Thank you, Justice Witt. The objection was ours, and it was premised on the following. This court had a case management conference and issued directions. Now, those directions were carefully issued. It took us a considerable period of time to work out who was going to go first, who was going to go second, and so on and so forth. We filed consistent with the directions of the court. We had significant difficulties as well in meeting our deadline, but we respected the court in its process. We met the deadline which we were required to meet. And then we saw these submissions coming, as it were, out of nowhere, and in circumstances where, not only, as my learned friend says, I wonder if your lordships are hearing.
Maybe if everybody else mutes that, it will go better. Could you proceed?
Yes. Well, we went off a bit. So we filed consistent with the directions given by the court, notwithstanding the fact that we too had considerable difficulties in observing the timelines, but we understood that the timelines were mandatory. And we certainly understood that they were mandatory in the context that, we were not prepared to come to court to ask for an extension of time. No extension of time having been applied for, no request of the attorneys, which is another procedure that is employed in practice. You would circulate your colleagues and ask them if they have an objection. And if they don't, then the application could even be by consent. That didn't come. We just saw these submissions. And we feel prejudiced by those submissions coming in out of time, inconsistent with the directions given and in the general circumstances that they were made. So we object.
Okay, thank you. It is a kind of an important point because in our schedule for today, we also made space for counsel for the other respondents. Of course, the counsel for the first and the second respondent got 60 minutes. And the counsel for other respondents, at least we had an opening for 45 minutes for them. But of course, as you all know, the rules of our court, I have to point that rule 14.4, which says that where a party has not filed and offered to exchange the party's written submissions within the time or times specified by the court, they shall not be heard at the hearing of the appeal except with the leave of the court. So and that rule should be known to all of you. So if you don't file written submissions, or if you are late and you will not get permission for an extension of time, then basically you are not allowed to give oral submissions unless you get leave of the court. So just to be sure about the procedure, is it that any one of the other respondents intend to give oral submissions, if that, while they did not file written submissions? It's a point of order, but it is necessary for us to know how to proceed. May I ask Mr. De Silva, for the Chief Election Officer, do you intend to give oral submissions?
Justice Smith, no, we do not.
Okay. Mr. Williams?
No, please, Your Honor.
Okay. Mr. Ramkuran, for himself and for Mr. Jonas?
Please, Your Honor.
No oral submissions?
No, sir, we do not want to waste the court's time.
Okay, well, that's great, but we have to know. And Mr. Hira?
No, please, Your Honor.
And Mr. Khan, did you intend to give oral submissions?
Your Honor, if I may. Sorry, there appears to be a trouble in the verb.
I think as soon as we don't speak, we should mute, because then we can avoid most of this.
Lord, I would just, if I might, I'm having some difficulties with the system. There's the feedback, but then I'm being booted off the system immediately after the feedback subsides. Not this time, the last time. So I just wanted to say that.
Yes.
Say that I have been in touch with the technical people at the court.
Right.
And I'm not sure what the difficulty is, but I just wanted to say that. No.
Okay, thank you.
Honor,
So,
if
Mr. Khan.
I'm sorry about that, but I seem to be having some similar challenges. I'm again reduced to audio. Your Honor,
As long as we can hear you, that's the main thing.
Okay. Your Honor, in terms of oral submissions, it was originally not the intention to do oral submissions. For this reason, the time that was allocated to the court by the court for the other respondents would have meant that each respondent would have had no more than 5 minutes or thereabouts. That being the case, in terms of the order in which we were in this matter, we are for the 12th and the 13th respondent, and therefore we were coming at the very end. So that my thinking on the matter was that in the event that when it got to our turn, there was little or no time left, given I was assuming that others would have put in their submissions, I would have been simply in a position to rely on my submissions in whatever time was left and be left at it. That was the
Okay.
original intention.
Yes, well, of course, the first thing is that as if we do not allow the extra time for the filing of the written submissions, then you have not filed them, and then you have no right to give oral submissions unless we allow you. Okay, so I think we will discuss whether you will get that that extension of time or not. We will decide
Chair,
that.
I see a hand raise.
Yes.
I could interrupt you. I see a hand raise.
By
Mr. Mendez has
Mr. Mendez.
indicated.
Yes. Okay, Mr. Mendez.
Thank you very much, Justice. I was just going to suggest as an option, because it appears that you have a 45-minute period that is not taken, that Mr. Khan might be, if in the discretion of the court, might be allowed to make his brief submissions after the two appellants, so that Mr. Jeremy will have, in his reply, be able to deal with all of the submissions that are opposed to him, so that Mr. Khan doesn't come after him, he comes before, so that he can address them. And of course, he would, I presume he will have read, even though it was late, Mr. Khan's submission, very short submission. That's just my suggestion, Your Honor.
Thank you very much.
If I may, Chair.
Yes.
Could I ask Mr. Khan to please explain for me why he made no application? It seemed, I found it painful that at this level, counsel should simply, out of time, send in submissions, and it seemed, and I hope I'm wrong, treat it as, well, look, we'll catch up on the matter that, we will catch up on this later. So, counsel, please explain why there was not any application for an extension of time or relief from sanctions. Thanks.
Your Honor, if I may, that challenge was essentially a personal one, and it had to do with the fact that well, I'm not sure how else to put this, but I was quarantined for a bit.
That's fine, counsel, but what I'm...
And I was not in a position to communicate with co-counsel on the matter.
I understand that, but you filed the submission
with some personal challenges. That is as much as I can. I agree that it is painful at this level, that this ought not to have happened. I make no sort of defense for that. But my challenge is related to something that was personally unavoidable.
Counsel, I have no problem with a practitioner or anybody having personal challenges which make compliance with deadlines not possible. But what I have a problem with is the failure at the stage when you were able to file those submissions. Why did you not make an application for an extension of time within which to file? It seemed, as I said, if not disrespectful, certainly inconsiderate. So I am troubled by it, and I want us to continue to be a court of excellence, and therefore I think it is a point that one must stick to, that there are certain ways to go about dealing with this sort of thing. That is really what is engaging me. Thank you.
Yes. Before we discuss this point, and we will not take much time on that, but the suggestion that if we would allow oral submissions, despite the lateness, etc., that in that case, Mr. Khan goes right after the other appellants, so that Mr. Jeremy and his team will know exactly what to react on. Mr. Jeremy, what is your reaction to that suggestion?
My lord, I have difficulties for the reason that I advanced before. Mr. Mendez did say that he assumed that I would have read them because they are short. I took the view that they were not properly before us. I think I'm entitled to take that view as well, and I might have cast an eye on them, but I did not pay much attention to them. So my objection remains, my lord.
Oh, okay, that is clear. So we will withdraw, discuss this point, and continue with the case. And unfortunately, it took some time, but in order to have an orderly process, we really need to go through this, and after that we will go back to the real case. So we will now withdraw, and we will be back within a few minutes. You can remain. We will be back, as I said, soon enough.
Yes, Judge, court resumes. Thank you.
Yes. Well, we are of the few that you know, in order to have a proper procedure, rules have to be followed. In fact, this case is about whether rules have to be followed strictly or not, in a way. But in any event, our court rules need to be followed. It's very easy. If you are late, it's very easy to ask for at least consent of your colleagues and certainly also of the court. No such thing was done. It is too late now. So unfortunately, Mr. Khan, we will not allow the filing of your written submissions, and therefore you will not be allowed to give oral submissions either in this case. But I'm sure that your points of view will be ably represented by the other appellants, or by the appellants. You're not an appellant, but by the appellants. So we now can go to wherefore we have come together. And I think the first party to speak is the Attorney General.
Thank you very much, Mr. President and honorable judges of the CCJ. Good morning. Your Honors, this appeal raises the neat, and I borrow the term neat from the Case Management Conference, the neat, narrow, and quintessential issue of whether an appeal lies to the Court of Appeal of Guyana from a decision of a High Court judge dismissing an election petition for want of service. The determination of this question, Your Honor, necessarily requires us to traverse that well-trodden journey of the historical evolution of the High Court's jurisdiction to hear and determine an elections petition, as well as is, if I may say, the jurisdictional idiosyncratic rules that are inextricably bound to the exercise of that jurisdiction. A jurisdiction that has been described as sui generis, as special, as limited, as restricted, as exclusive, etc. Linguistic expressions that bear a causal nexus to the evolution of the jurisdiction itself. I am aware that this honorable court is intimately familiar with that historical evolution and the attendant peculiar rules that have evolved with it over the years, coupled with relevant judicial pronouncements whenever the jurisdiction has been invoked. I say so in recognition of the fact that quite recently, this court had the responsibility of interrogating that question arising out of an appeal from the Commonwealth of Dominica. I also say that in recognition of the fact that this court interrogated the question in Christopher Ram, and I believe in Ali and Jagdeo to some extent. So the issues are well known, but Your Honor, for the record, I wish Your Honor's kind permission to rehash them quite briefly. Your Honor, it's a special jurisdiction that was inherited from the House of Commons, transferred to the High Court, with a special statutory or constitutional code, as in the case of Guyana. And it's captured in Article 163 of the Constitution of Guyana. Because of its special nature, Your Honor, the authorities have been legion in adumbrating very clearly that the jurisdiction is confined almost in a straitjacket fashion to the four corners of that statutory code and bears no importation of procedural rule or statutory framework outside of that statutory code unless the statutory code itself permits such intrusion. And in my submission, I have alluded to a Jamaican case that speaks to, in Jamaica, the CPR being allowed by statutory intervention to form part of the code to which I speak. Your Honors, in that code, Article 163 sets out what are to be challenged in an election petition, and once certain questions are determined, where an appeal lies, and speaks to Parliament having a power to establish a statutory framework and rules governing the exercise of that jurisdiction. This court, in Christopher Ram case, conclusively pronounced that the statute to which the Constitution refers in Guyana context is the National Validity of Elections Act and the accompanying rules. And it is a combination of Article 163 and that statute along with the rules that concatenate to create this complete statutory code. Your Honor, if I may go to Article 163.4, which provides for the empowerment of Parliament to pass that legislation. 163.4a speaks to the circumstances and manner in which the conditions upon which proceedings for the determination of any question in this article may be instituted in the High Court. That has been done in the form of the National Assembly Validity of Elections Act and rules. And then it goes on to say, and an appeal may be brought to the Court of Appeal in respect thereof. Well, we have no statutory provision to that effect. And at C, it speaks to the practice and procedure of the High Court, and again, reference is made to the Court of Appeal in relation to appeals to the Court of Appeal under this article. Again, we don't have that statutory code speaking to the Court of Appeal. What that leaves us with, Your Honors, is Article 163.3 that speaks to an appeal shall lie to the Court of Appeal from the determination by the High Court of any such questions or against any order of the High Court made in consequence of such determination. Now, it is common ground that the questions that the petition raised were not determined, and therefore an appeal does not lie to the Court of Appeal as those questions have not been determined. And Your Honor, that is the policy, or rather the scheme of election legislation or election dispute legislation. In the Eastern Caribbean, for example, Your Honors, they speak to a final order or an interlocutory order. And Your Honors had a deep juridical excursion into that question in the Skerritt case quite recently, to which I've made reference. In Guyana, we don't have that dichotomy. But the policy remains the same. That is, that only final orders are appealable in election disputes. And this honorable court again in Christopher Ram proffered the reason. One, it said, and I commend that statement to this honorable court. One, that election disputes must be resolved quickly and expeditiously. And secondly, that preliminary matters or matters that are not determined on their merits are not appealable in elections disputes. If your honors are to examine the order, or rather the judgment of Chief Justice George, her honor quoted copious authorities that aggregate to say that when procedural requirements are not met, the impact and legal effect is that it affects the validity of the petition itself, it nullifies the petition, and that principle is inextricably linked to the jurisdiction of the court to entertain such a defective petition. And those two principles marry to prohibit an appeal because there is really no decision from which one can appeal. Because the petition is a nullity, the petition is defective, and the court, and that constitutes a jurisdictional bar to the court entertaining an appeal, entertaining the matter itself.
Honorable Attorney General, can I interrupt you?
Yeah.
Because you're on a point. If you prefer that I wait, I can, but if you would allow it, I'm happy to ask you a question. What is your preference?
I would prefer, Your Honor, at the end.
All right, fair enough.
Can do that. And that is the policy, Your Honor. The Court of Appeal, and that is recognized, Your Honor, in our Constitution that creates the right of appeal in constitutional matters. Article 2, one moment, Your Honor. Article, I'll get to that article. No, not 123. 133 of our Constitution, the drafter recognizes the very principle that I am referring to by exempting from the operation of that article matters that fall under Article 163, where an appeal to the Court of Appeal shall lie as of right from decisions of the High Court in the following cases, and they list the cases: final decisions in civil or criminal proceedings and question as to interpretation of the Constitution. One can very well argue that this case involves an interpretation of an article of the Constitution. And I don't wish to get involved in the final or interlocutory order, as I don't think that it is relevant to Guyana's jurisdiction. But nevertheless, Article 133(2) says very clearly that nothing in paragraph 1 shall apply to matters for which provision is made by Article 163. And that is in keeping with the policy of the statutory code. Your Honor, the Court of Appeal Act has no place in this statutory code. No place at all. And I can draw a live example to demonstrate the point. Our National Assembly quite recently heard a privileges motion and made a determination thereof. Now, that is not a jurisdiction that Parliament handed to the court. Parliament kept that jurisdiction. And Parliament, in the exercise of that jurisdiction, made a pronouncement via that privileges committee, it is unthinkable for one to suggest that the Court of Appeal Act can be invoked to file an appeal against a decision of that privileges committee. I think that graphically explains, or rather demonstrates the point that I want to make. And Your Honors, unless that fundamental core principle and concept is understood, then we are not going to get it right. And I dare say with the greatest of respect that the Court of Appeal of Guyana did not get it right, because they sought to find an appeal and ground an appeal where one does not exist, using the conventional provisions of the Court of Appeal Act. And I made it an express point in my submissions that the predicating language of that Court of Appeal Act says any cause or matter. And all the literature on elections petition law say very clearly and unequivocally that an election petition is not an ordinary litigation, is not a civil suit, is not a suit in equity. It is something that is unknown to the ordinary jurisdiction of the court. And Your Honor, the Court of Appeal, I dare say, fell into error, trying to use Article 123 of the Court of Appeal Act of the Constitution, which speaks to the establishment of a Supreme Court, which includes the High Court and the Court of Appeal, and that court shall have such powers as given to it by Parliament. Well, Parliament, for the purpose of election dispute, did not give that Court of Appeal any such statutory power. And to use the Court of Appeal to say, Court of Appeal Act to say that that is the statute is completely misconceived and certainly demonstrate a lack of understanding of the historical jurisdiction of the court and how it evolved. And Your Honor, therein lies the key to addressing this question. Your Honor, tangential to that also is the fact that an appeal is a statutory phenomenon. It doesn't exist. It's an animal unknown to the common law. And therefore, if one is asserting a right of appeal, one must find the statutory vehicle that establishes that right of appeal and takes that right of appeal to its logical destination. And the respondents have abysmally failed to establish that statutory right of appeal. They seek refuge in the ordinary Court of Appeal Act, and that is not available to them. In fact, the policy of the Court of Appeal Act itself prohibits the hearing of appeals that are not of a final nature. And as the case from Dominica recently demonstrates, and a disposal of an election petition at what the court describes at an intermediate level, meaning without determining the questions that cannot be a final order, and by the Court of Appeal Act itself, is unappealable to the Court of Appeal, assuming that one wishes to interrogate that as one of the bases. Your Honors, in my submissions, I went through the reasoning, or I tried to, of the Honorable Chancellor, as well as Justice of Appeal Barnes. And I sought to identify what I consider to be the deficiency in the reasoning advanced. and they are well set out in my submissions. I don't intend to recite them here, other than to emphasize that these two judgments aggregate to depart from the statutory code and the common jurisprudence that govern election disputes. There seem to have been inherent in the two judgments some sense of judicial abhorrence against the fact that such a pivotal decision can be unappealable. Well, Your Honor, in my submissions in the court below, that is the Court of Appeal, I put before the court cases coming out of Kenya and the Kenyan statutory code to show that there are certain type of decisions in Kenya that are absolutely not appealable. And they are very crucial. They are election disputes matter. And the statutes say that they are unappealable. In Kenya also, and in many other jurisdictions, there is a two-tier procedural ladder constructed, whereby if you have interlocutory matters, you can't appeal them until there's a final ruling or a determination of the final issues. And then you are required to roll up your issues and make one appeal. So, and the point, the fundamental point remains that appeals are statutory. And if a statute doesn't confer that right, then it does not exist. Justice of Appeal, Gregory rather, attempts to read into the Constitution, Article 163, a jurisdiction because, according to Her Honor's reasoning, there were no what I believe he described as exclusionary clause. But I cited dicta, Your Honor, to show that an appeal can't be by implication. An appeal is conferred expressly, and one can't read into the Constitution some implicit and implied right to appeal or of appeal when such a right was not expressly conferred. In addition to that, counsel for the respondents have relied again on Section 42 of the National Assembly Validity of Elections Act to argue that that act, that section rather, equips the High Court hearing an elections petition with all the powers that a High Court would ordinarily have in hearing an ordinary matter, and therefore that elections court or a court hearing an elections petition is conflated, for want of a better word, with the High Court sitting in its ordinary jurisdiction. Well, if that is the position, Your Honor, then the whole tenor of the jurisprudence touching and concerning election disputes would go out of the window, because it would no longer be restrictive, it would no longer be exclusive, it would no longer be sui generis, it would be ordinary. So that argument on the face of it ought to be rejected out of hand. But I have cited in my submissions in the Court of Appeal the dictum of Chief Justice Chang in the case of Ganga Prasad, a case which I argued in the High Court of Guyana, where Mr. Ford advanced a very similar argument. And Justice Chang rejected that argument. And I have quite an expansive extraction of His Honor's reasoning for rejecting that argument. And I commend that reasoning to this honorable court, that Section 42 must be read contextually. Section 42 is part of that statutory code. Section 42, for example, it speaks to High Court rules or rules of court. And when you go to the definition in the legislation itself as to what rules of court speaks to, they do not speak to High Court rules. They speak to rules made under or referred to under Article 163, which goes back to the special code again. Also, I drew attention in those submissions to the fact that the rules of code for the purpose of elections petition is a completely different regulatory infrastructure and has nothing to do with the civil procedure rules. For example, I cited in 1950, there had to have been an amendment to those rules to allow for the consolidation of election petitions, whereas consolidation was a concept and a vehicle available under the High Court, the then High Court rules of 1955 in Guyana. And therefore, if the High Court rules had applied and the court had the ordinary powers that it is being contended that it had, then you would not have had to go to that extra and special step to amend the special regulatory infrastructure to allow for consolidation. Another example, Your Honor, lies in the fact that every time we amend the High Court rules, if they were applicable to the election regulatory framework, then we would have had to amend the rules of court here under the National Assembly Validity of Elections Act. Or those amendments would have applied mutatis mutandis. I have never seen a pronouncement from any court that has put forward that type of interpretative analysis or a comparative examination of the two regulatory framework. When we introduced the new CPR, for example, what impact did that have, if any at all, on the election regulatory framework? Absolutely none. And the CPR themselves stand as a testimony to that by their express language. They make no reference to election petition and election petition matters. Why? Because that is part of a statutory code that is over 300 years old and which exists in all the Commonwealth territories that were handed down this legal system by Her Majesty's government through colonialism and colonial rule. So, Your Honors, the valiant and disparate and desperate attempts to carve a jurisdiction for the Court of Appeal to adjudicate on these matters are simply futile and cannot be countenanced. If we do that, Your Honor, every pronouncement that this court has made in Christopher Ram go through the window. This court very clearly in Christopher Ram's case spoke at length about the type of jurisdiction, the special right, the special procedure, quoting from established cases that have become legendary in at least the Guyanese jurisprudence and the Caribbean. And when the pronouncements came from P3 and then C. Kumar Singh and a whole host of other cases, Guyana is a very litigious country when it comes to elections. When those principles first came forth, they were viewed with alarm, I must say, because I've spoken with older lawyers and so on. But when they're observed now and they're recognized and you look at the comparative pronouncements across the Commonwealth and of course in the region, they are part and parcel of a same pattern, historical and jurisprudential pattern. And these cases, they offer very little space And that is why, Your Honor, as recently as 2 weeks ago, Your Honors had to deal with the same question, and that is how you concluded. The identical issue, an election petition was disposed of without the determination of the questions raised in the petition. That is, whether the elections of Dominica was conducted in accordance with law, whether there were irregularities, whether there were specific election offenses committed. And Glasgow J, my batchmate actually, Ralston Glasgow, I'm very proud of that judgment, interrogated the matter fully and concluded in what from all appearances was a sound and well-reasoned judgment, concluded that they did not meet the threshold for going to trial. And he ruled accordingly. It is the same juridical animal as this case. Justice George said in her ruling that she couldn't. The gate was not open for her to determine the questions and disposed of the matter in the same type of juridical pronouncement, in the same factual scenario, almost. And the Court of Appeal in Dominica rightfully declined jurisdiction, and Your Honors affirmed that decision, and rightfully so. In that case, Your Honors had to deal with the added question of a constitutional right to a fair hearing. Now, that does not arise here. So Your Honors do not have to necessarily burden yourself with that matter, which is extraneous to this. Here is a pure question of whether the appeal lies or not. And I dare say, Your Honor, there is nothing on the record that establishes a right of appeal as is being argued by the respondents. And Your Honors, multiple analogous examples are being given in the judgment. Multiple cases are cited from all across the globe. Your Honor, our statutory code is clear. It has its deficiencies, but that is the statutory code. And that is what this court is bound to interpret and apply. And I dare say, Your Honor, that is the position of Guyana. We have enough authorities and pronouncements in Guyana on the matter. So there's no need to go outside. The other last point I want to make, I make signal that I'm running out of time, is, Your Honor, there is one case, I believe, that has been determined in Guyana on its merits. Though we have had elections, petitions filed in Guyana from independence to now on multiple occasions, and I have appeared in at least, I believe, about 5 of them. And I believe all of them were, well, other than Gladys Petrie, not Gladys Petrie, other than Esther Pereira, all the others were disposed of on preliminary grounds. And this court is aware of most of them. They would have been referred to by Chief Justice George, her father's decision, Chancellor George, who was then Chief Justice, and many other High Court Justice, Chang in Melville. I appeared in that one as well. In all these cases, Your Honor, they were disposed of on preliminary grounds. And there must be a reason why no appeal was ever filed. No appeal was ever filed, and there were lawyers of great eminence who appeared in these matters. Is it that all these petitioners were not aggrieved by the ruling that disposes of their rulings that disposed of their matter in this preliminary way? Is it that all the lawyers were comfortable with the decisions? It cannot be. It is because it was always recognized that these decisions are not appealable. So at this stage in the year 2022, to attempt to persuade your honors to undertake the Herculean task, the legally impossible task, to create a jurisdiction out of a vacuous situation, is to invite your honors to fall into error, grave judicial error. And I'm sure your honors would not want to do that and would resist that very emphatically. Your honors, I will pause here with your honors' leave. And I know Justice Jamadar is rearing to interrogate me. I hope that I can withstand the probing.
Well,
Thank
Attorney
you.
General, I am not biting at the bit to interrogate. I just have a question in my head, a small one. I'm certainly not putting on the garb of Hercules at this time. So let's put all of that aside. Let's stay with the main framework of your submissions, which is that the jurisdiction to appeal must be found within either the constitutional or statutory, including rule regime, and that is the Constitution together with the National Assembly Validity of Elections Act and rules. I think that much is at the heart of what you've said today. And so my question is, looking at 163.3 of the Constitution, which establishes, well, let me ask, do you agree that 163.3 establishes two bases for an appeal to the Court of Appeal, as enumerated A and B?
Yes, Your Honor.
All right. B is where there is a determination of a substantive petition. I'm just summarizing. In other words, you have an order or you have, you agree with that?
Yes, Your Honor.
Good. So my question revolves around what does A mean? So B clearly has not occurred in this case. Now, in Guyana, is there a procedure that provides for a leave stage in the hearing and determination of an election petition to be found within the statutory and regulatory framework that you have established for your arguments?
No, Your Honor, but the courts have...
Oh, no. Before you reach the courts,
yeah.
let's stay with because your argument was premised on a principle, as I understand it. I will hear what you have to say about the courts in a moment. Yeah. I just want to stay within the framework of your argument, because your argument is the court's decisions all the courts, you say to us, do not undertake this Herculean task because you are limited. An appeal must be grounded in statute, and in this case, you are limited to three documents: the Constitution of Guyana and the National Assembly Act and the National Assembly rules, because those are passed pursuant to the Constitution by Parliament. And so that's what you call the regulatory regime. I'm fine with that for now. You say that courts must not do anything more. So I'm staying within that framework for now. So what I'm asking you is, and I think you have answered, this constitutional statutory framework does not provide procedurally for a leave stage in the hearing of election petition. For example, in public law, we all know in judicial review that is so. You can have a Judicial Review Act, you can have your CPR rules in which there is a leave stage, or in an application, an appeal against a question of costs only, most of the common law jurisdictions, you must, by statute, you must get leave of the court to appeal. So we agree then, for now, that there is no statutory structure which includes a leave stage. Yes?
That's correct, Your Honor.
Yeah, good. My question, therefore, is this. When 3A says an appeal shall lie, I assume as of right, to the Court of Appeal from a decision of the judge granting or refusing leave to institute proceedings. My fundamental question is, what does that mean? Because we have no leave stage. In other words, let me use an analogy, and then you can respond. In judicial review, you make your application for leave. That application could be resisted or not. And if it is at the end of that application, the court says leave granted, gives directions, or leave refused, dismisses the notice, and may make orders for costs. So what is it that the Constitution contemplated at 163.3 when it uses the language from the decision of a judge granting or refusing leave to institute proceedings for the determination of any of the questions in one?
Thank you very much, Your Honor. Your Honor, in my submissions, I spoke to deficiencies in the statutory code. And those deficiencies have existed from time immemorial. While 163, let's go to the part that is not disputed. An appeal shall lie to the Court of Appeal from determination by the High Court. We are to reach the Court of Appeal. But conventionally, parties utilizing this jurisdiction have always used the form applicable to file appeals to the Court of Appeal. The question that Your Honor is asking me arose in Chaitan and Gypsy. And I believe the question had to be what, because I think in Trinidad there is a similar vacuum. And I believe the ruling was any form applicable, any procedural vehicle that would be acceptable can be used. And that has been the position in Guyana as well. In fact,
Mr. Attorney General, yeah, I understand the John Doe principle. I'm good with that. I'm asking something a little bit different, I think. I don't know if I've not expressed myself clearly enough. I am not on where there is a lacuna, where there is a right provided and there is a lacuna in the provision of a process that the court must find a process to give effect to the right. That's a John Doe principle. That's fine. So if there is nothing that says how you appeal, but the Constitution gives you a right of appeal, then of course the court provides for a reasonable procedure. I'm not troubled by that at all, but I'm not asking that. You are right, 3B is clear. A ground of appeal is where there has been, remember we are on a question of ground of appeal and jurisdiction. A ground of appeal, a right of appeal, I should say, sorry, lies where there has been a determination by the High Court of any of the questions at 163.1, i.e. the validity of an election petition. All right, so wherever there has been a determination by the High Court, Chief Justice George heard the case and decided yea, no, nay, in between. There's a determination. 163.3b says you have a right of appeal. Work out the procedure if you don't have one. You have a right of appeal. Now, what I'm asking is about 163.3a. 163.3a also gives you a right of appeal. I'm not talking about how to appeal. I'm a priori. How? It gives you a right of appeal. My question is, what is the right that is being given at 163.3 where it speaks to a decision? You must have a decision. So let's look at it. You agree you must have a decision of the High Court? Yes. Attorney General, looking at the section, do we agree you must have at least a decision?
yes, granting or refusing leave.
Right. 2, institute proceedings.
Yes.
So wherever there is a decision that either gives permission or refuses permission to institute proceedings, proceedings for what? to determine any of the questions at one, i.e. validity of election petition. So my question is, what does it mean to say that wherever you have a decision that grants or refuses permission, I'm substituting the word permission for leave because we have no leave process to institute proceedings to determine a question, you have a right of appeal. Is that what this is saying? On the plain English, tell me what, first, maybe let's do it in a simple, in a structured way. What does the plain English of this mean? Before we don't tell me about courts and interpretation of court. Let's just look at the plain statutory language that is given this right of appeal. What does it mean?
Your Honor, it means exactly what it says. That is, that, and the petitioners would have had to satisfy that requirement even in this petition, that before you file the petition, you go and you get an order permitting the filing of the petition.
Is that in the statutory regime in Guyana? That there's a first stage?
First of all, well, it is in the Constitution, which is part of the statutory code.
Where is that in the Constitution? Where is it say in the Constitution that before you can bring a 163(1) election petition, you must go to the court for some, I don't know, leave? Because if that is there, then that's the answer. That satisfies me completely. I am happy with that. If that's there, where is that?
It doesn't say that. It proceeds obviously on the assumption that that is a requirement, and we have a written judgment on this very issue, Your Honor.
All right,
and I will forward it to Your Honor. This very provision was interrogated, and I will forward it to Your Honor. But perhaps Section 3 of the National Assembly Validity of Elections Act.
Wait, hold on. Section 3 of the Act, you said?
Yes.
I know I've looked at it. Let me just get it quickly here. 1 second. I'll pull it up now. Just give me one moment. Yep, I have it. Section 3. Method of questioning. Yep, I looked at that.
So there is also reference to 163A in that statutory code as well. But Your Honor, I am happy that.
No, wait, hold on. 3 speaks to a question. In other words, 3 is saying any of the questions, I agree, in 133(1) are the subject of a fair enough, but I'm not asking that. I'm asking something different.
I know what Your Honor is asking.
Yeah.
Where is the requirement?
I'm not saying where, no, I'm asking, is there?
Is there?
Because if there is no requirement, Honorable Attorney General, then we have to make sense of what 3A covers constitutionally.
Yeah, and as I said, Your Honor, I didn't consider this relevant to the appeal at all. But now that Your Honor is asking me about it, I want to say 2 things. One, that we have judgments on this matter, I believe, from the Court of Appeal and the High Court, which I would like to put before the court. And secondly, Your Honor, this provision here again goes against the very scheme of the Court of Appeal Act because it grants leave pursuant to an ex parte application.
Well, that's what I'm grasping at. You say no, this is the Constitution of Guyana. And the Constitution, you're talking about pursuant an ex parte application and so on and so on.
Practically, the application is done ex parte in practice. And that is how Mr. Ford and those who commenced this petition would have done it. I had to do it when I did Ganga Prasad in 2015, and that's how every petition is commenced.
So there is a practice that you come for leave?
Yes, please, Your Honor. And Mr. Ford can confirm.
No. You see,
granted leave.
And where is that found? What is it? You see, what is the statutory basis for that?
Well, Your Honor,
Or is that relying therefore on the what is it, 138, the Section 30, the Validity Act, where you look at the UK Parliament or something? Where are you getting that from? Because the Constitution simply says what it says. And the question in my mind is the Constitution, is that section broad enough to say any dismissal? Or is it limited to the, so that are you saying then there is a practice?
There is a practice, Your Honor, I can confirm it, and I don't think anyone on this screen can dispute the existence of that practice, that as a condition precedent to the issuance of an elections petition, an application is made to the High Court for leave, and that application, it is after that application is made and granted that the petition is issued. Okay. And as I said, the provision was interrogated, and there is a written judgment, or there are written judgments on this issue. But I hasten to say, Your Honor, that, well, I don't see the relevance of this to the issue at hand. But of course,
it's fine. It's fine to say that, because, yeah. and I take absolutely no offense at that, Attorney General. That's fine. So that this 163(3)(a) is related to a practice outside of the statutory regime that is actually a leave application. Is that what you're saying?
Yes, Your Honor.
All right.
It's akin to a leave application. And as I said, in the case that it was examined, guidance was taken from the Court of Appeal in Chaitan's case, because this very issue arose in Chaitan's case out of Trinidad and Tobago.
Honorable Attorney General, you spoke a short while ago about several matters that you knew that had been dismissed on preliminary grounds. And you said, as far as you were aware, only one matter was heard on the merits. Did I get your submission right?
Yes, Your Honor.
Yeah. As far as you're aware, Attorney General, when those matters for leave come before the High Court judges, has there been an appeal from the refusal or grant of leave in any of those cases, as far as you know?
In one, I believe there was an appeal, and it had to do with the procedural vehicle used to make the application to the High Court judge. So it explored a procedural question. And I believe the Court of Appeal said that in the absence of a specific laid out procedure, then any one of the acceptable mode of procedure utilized in the High Court can be used. I think that decision is Veronica Dell. I can't remember the name, but I can provide those decisions to the court. I can do that.
Thank you. And one other question, Attorney General, when you spoke about these applications for leave before the High Court judge, what forms would be used? What procedural rules would be followed? Would the application say this form is, would someone suggest, in other words, look, if you have to do it to a young attorney who may be doing this for the first time, look, use the JR leave form that is in the rules, or how does the court look at the application and think that it has met all the requirements, and of which rule? Can you assist? Thank you.
Your Honors, as I said, the position is flexible. Ordinarily, I think originating summons have been used with an affidavit in support, along with a copy of the petition appended to the affidavit. And it's normally heard and determined ex parte. That has been my experience. That is how I have done it. And no one has raised any issues in relation to that.
Mr. Attorney General.
Yes, please, Your Honor.
Doesn't good old Erskine May on parliamentary practice and procedure provide the forms for this sort of thing?
Your Honors, maybe I can't speak directly to it, but I can speak to the reference in the National Assembly Validity of Elections Act to the procedure. Section 38 of the Act says, subject to this Act and rules of court, and the rules of court are these rules, the principles, practices, and rules on which committees of House of Commons of the Parliament of the United Kingdom used to act in dealing with election petition shall be observed so far as may be by the court in the case of elections petition. So, Your Honor, is spot on. Without me checking directly, there is a reference to that in the statutory code, and therefore I have no doubt that Your Honor is on the right path.
So Attorney General, just to complete this circle, so therefore the House of Commons practice has been incorporated. You see, you put your argument in a very, very tight box. Now I think you are. I asked you a little earlier about Section 38 and the House of Commons practice. So do you now agree then that the statutory regime that is provided for by the Constitution and the National Assembly Act and rules includes sections 42 and 38 and 42 of the Validity Act, which Section 38 includes the principles, practices, and rules of the House of Commons in relation to election petitions, and therefore we can, in determining what can or cannot be done, at least we can look at that. Do you agree with that? Right.
Certainly, Your Honor.
And in relation to section, I know that's fine. In relation to section 42, which is doing the same thing, except now in relation to proceedings, as if the proceedings were an ordinary action within the jurisdiction of the court. So why do you, on one hand, help me say, okay, so section 38, you see, your argument started within a very narrow, the narrow confines of what was here. You said stay here. Now I agree. You are saying, well, okay, section 38 allows us to look a little further and by importation, incorporate principles, practices, and rules of the House of Commons. All right, be taken one little step. Why do you therefore say, a fortiori, section 42?
Your Honor, first of all, let me say that I have said from the beginning that the statutory code embraced by the Constitution and the National Assembly Validity of Elections Act apply. And that's all that applies. And whatever are contained in those codes apply. And I am respectfully submitting, Your Honor, as I did before, and that's why I asked this Honorable Court to have regard to my submission before the High Court, before the Court of Appeal. I thoroughly examined Section 42 at pages 10, 11, 12 of my submissions before the High Court and explained that Section 42 has to be read contextually.
Yeah.
Yes.
So do you say a same thing in relation to the Section 38 importation of the House of Commons rules?
Yes, Your Honor, it must be, because they are all subject. Section 42 begins with the condition precedent subject to this act and rules. Subject.
No. So therefore now, can we therefore agree? at least theoretically, that for the purpose of election petitions, the corpus of the rules, so statute legislation and rules that govern the process can be found in the Constitution, the Validity Act, the Validity Rules, as well as, but subject to the former, as well as in the House of Commons rules and in the ordinary practice of the courts.
Your Honor began by saying that if we can agree, I don't think we ever disagreed.
Well, great, that's fine. I just want to be clear. Thank you very much. That's all I want to ask.
That's what I said this time, the four corners of a code. Wherever the code takes us, that's where we have to go. But outside of that, we go no further.
Agreed.
Mr. Attorney General, did I understand you correctly saying that only once an election petition was decided on the merits?
In Guyana, yes.
In Guyana?
Yes.
That doesn't sound like a very effective method of challenging elections then. Wouldn't you agree that whatever we think about how to solve this, but wouldn't you agree that this system, as you describe it, gives an awful lot of power to a first instance judge? Because the judge can use any procedural device to torpedo the whole issue. I'm not saying that the Chief Justice did that in this case or whatever, but theoretically.
Your Honor, sorry.
And the judge might, for example, and I'm not saying that that is the case here, but there may be a case where the judge is manifestly wrong, but you will still say, well, we have to accept that because this is simply in no way appealable. These procedural decisions are simply not appealable. Do I understand you correctly?
Your Honors had to deal with that question in the Dominican case.
Correct, yes.
And Your Honors correctly pointed out that the decision is unappealable either way.
Yes.
I could have made a most compelling case of a flagrant breach of procedure, and the judge could have said, no, I reject that, and that would have been the end of the matter. And that is the nature of the jurisdiction.
Yes.
Because the larger policy directive is governments have to get on with the business of governing. Yes. This concerns the election of members to the National Assembly and the formation of government, which underpins the rule of law.
Yes.
And you said that very elegantly in RAM.
Yes, no, we understand that, and it has been expressed by this court. So, that is fine. But I understand in this case there were two petitions, and one was stopped because of the procedural issue. Another one was allowed to proceed, correct?
I can't recall what's the status of the other one.
Yes.
I can speak to this one. I can't recall right now.
So, looking at it in a very distant, from a very distant. So the system is very eager to punish, let's say, a few days delay in service, because that is what we're talking about. But then we are now 2 years after that election. That one petition that was allowed to continue is still somewhere. And Guyana is not the only country where this happens. It would seem when I read these cases that they take an awful long time. So what about this urgency to deal with these things quickly? We all understand why that is necessary, but in practice, there doesn't seem to be that urgency.
Well, Your Honor, Your Honor, you are possibly far better placed than I am to speak to the alacrity with which the judiciary must work. We are prepared every day to go to court, every night to go to court, and perhaps the pinnacle court should help us to move the process along, but that's beyond the realm of the executive.
Okay, great. Thank you very much. So we are now at 11:32. I don't know. We could we are not on schedule, but maybe we could take a 5-minute break and then continue with Mr. Mendez. Is that agreeable?
Your Honor.
Okay, so Madam Deputy, we will pause for 5 minutes and then we'll hear Mr. Mendez.
Thank you, Judge. Court adjourns. Thanks.
Okay, Mr. Mendes, the floor is yours.
Thank you very much, Your Honor. If I may just take up that conversation you were having with a learned friend, Mr. Nanlan, just before we left, as to what happened in relation to the other petition. In fact, it was determined on its merits. I don't know if my learned friend, Mr. Nanlan, was referring to that as being the only one that was determined on its merits, or whether there was another one. But that petition was determined on its merits. The main point in that case was whether the recount or the order under which the recount was held was constitutional or otherwise ultra vires, and that was determined and the petition was dismissed. I do not know what has happened since then. We have heard rumors of an appeal, but we have never been served with a notice of appeal. And certainly an appeal has not been pursued, meaning that we have not been summoned to any proceedings before the Court of Appeal, if there in fact has been an appeal. So that to give a full answer as to what has happened, that petition was determined on its merits and dismissed on its merits.
Thank you.
Just to be clear on that point, Mr. Mendes, that is a matter which can be appealed, is it?
Yes, because it was the court determined the question whether the election was valid or not.
So it falls within 163(3), or is it 3 or 1?
163(3)(b).
Okay, wonderful. Thank you.
Yes. Your Honor, if I may begin by dealing with one of the pillars of the respondent's submission, which you would find at paragraph 10, electronic page number 5474. Paragraph 10 of their 18-page submission, which if I may point out, I didn't stop reading it after page 12. But the submission there is that the jurisdiction vested in the High Court under the National Assembly Validity of Elections Act is a jurisdiction that is vested by Article 123(1) of the Constitution, and presumably, therefore, not by 163(4) of the Constitution. And the theme of the submission basically that the jurisdiction that is being exercised there is therefore the ordinary jurisdiction of the court, and therefore the laws applicable to the ordinary jurisdiction of the High Court therefore apply, which takes you to the Court of Appeal Act. So the short answer to that point, of course, is that this court has already determined that the National Assembly Validity Act was passed pursuant to the powers under Article 163(4), and you will see that in the RAM decision at paragraph 35, electronic page number 4888. But the longer answer, I think, is important in order to understand the history of the provisions that the court is being called upon to construe, and also it may also tease out what has happened or what was the Parliament was thinking about, or I shouldn't say Parliament, the framers of the order in council were thinking about when they made provision for an appeal on the grant or refusal of leave to institute proceedings. And this has been the subject of the supplemental bundle of documents that we put before the court. What is now the National Assembly Validity of Elections Act was originally regulations made by the governor, it would appear, and they were called the House of Assembly Validity of Elections Regulations 1964. And you will see those beginning at page 6398 of the electronic bundle. And the regulations were declared you'll see on the first page, 6398 have been made under the British Guyana Constitution orders of 1961 and 1964 in the exercise of the powers conferred by Section 3.4 of the 1964 order and Article 70 of the Constitution at that point in time. Now, those regulations included the provisions that were mentioned earlier on today. That is to say, what is now Section 38 of the Act dealing with incorporating the procedure of the House of Commons in the United Kingdom, and also providing that the court has the powers of the High Court in its ordinary jurisdiction. And you will see that those provisions at electronic page number 6410. It was Section 37 at that point in time. At the top of that page, subject to these regulations, the principles, practices, and rules on which the committees of the House of Commons, etc., use to act shall be observed. And then Section 41, which is now Section 42, which says, court shall, subject to the provisions of this Act, have the same powers, jurisdiction, and authority with respect to any proceedings brought under and by virtue of these regulations, as if the proceedings were an ordinary action within the jurisdiction of the court. So that existed then. The Guyana Independence Order then came into being in 1966. And you will see that beginning at electronic page number 6289. And it was that constitution that created the Court of Appeal for the first time. The Court of Appeal of Guyana did not exist prior to the 1966 order. Prior to that, appeals went to the Federal Supreme Court, and there may have been other iterations of the appeal courts at that point in time, but the Court of Appeal of Guyana came into existence with the 1966 order. And you will see that section, what is now section Article 123(1) of the current Constitution was then section 83 of the order, which you will see at page 6345. Section 83(1) says, there shall be for Guyana a Supreme Court of Judicature consisting of a Court of Appeal and a High Court, with such jurisdiction and powers as are conferred on those courts respectively by this Constitution and any other law. And then you had what is now 163 of the Constitution, and it was then section 71 of the 1966 order. So it is now 163, almost in identical terms. And 73(1) provided for appeals to the Court of Appeal. Appeal shall lie to the Court of Appeal from a decision of, it's in the same terms practically, from a decision of a judge of the High Court granting or refusing leave to institute proceedings for the determination of any question referred to in paragraph 1. And then B in the same terms as Articles 163(3) at that point in time. And then you had in 71(5) the power given to Parliament to make provision with respect to the circumstances and manner in which and the conditions on which you begin proceedings or an appeal to the Court of Appeal. So, and that would be the equivalent of 163(4) under the current Constitution. So it is at that point in time that when the Court of Appeal of Guyana is created, that the legislature, if I may use that term loosely, vested in the Court of Appeal of Guyana a jurisdiction in relation to election petition, or if I may put it this way, election matters. And that was against the backdrop of the existence of those regulations that I've just referred to you, created in 1964, which later became the National Assembly Validity of Elections Act. And in that regard, if I may, it might then take you to Act number 16 of 1968, which is at electronic page number 6375. And that act is called the Representation of the People Adaptation and Modification of Laws Act 1968. And the relevant provision is section 4 at electronic page number 6377, which provides, in connection with every election after the commencement of this act, the House of Assembly Validity of Election Regulations 1964 shall, subject to the provisions of this section, have effect as if enacted under paragraph 5 of Article 71 of the Constitution, and all other provisions of the Constitution thereunto enabling, and for that purpose be construed with any necessary adaptations, modification, etc. So that this provision is now saying that those regulations are now deemed to have been made under what is now Article 163(4) of the Constitution. So that what is now Section 42 and what is now Section 38 of the National Assembly's Validity Act are deemed to have been made not under Article 123(1) of the Constitution, as the learned friends have submitted, but they are deemed to have been made under Article 63(4) of the Constitution. The last development is that when the 1980 Constitution came into being and effectively reenacted Article 71 in Article 163, there was an order made, Order 50 of 1980, and you will see that at electronic bundle page 6436. And at page 6437, paragraph 3 of that order, it is said, the National Assembly Validity of Elections Act shall have effect as if it were enacted by Parliament for the purpose of providing for the determination of questions relating to the validity of election of members of Assembly under a system of proportional representation and so on. So that there's this order made pursuant to the Constitution Act of 1980 that brought the 1980 Constitution into being, effectively repeating what had been said in the 1966 Constitution, which is that what is now the National Assembly Validity of Elections Act is deemed to have been made by Parliament under Article 63(4). So that, contrary to what my learned friends have submitted, the scheme is not one that is bifurcated as between the special court or the special jurisdiction that is granted in the High Court and the special appellate jurisdiction, we say, that is granted in the Court of Appeal by Article 63, and then the National Assembly Validity of Elections Act. It is one code that has been created and is not bifurcated between different courts, such that when you are doing one thing, you are acting in the ordinary jurisdiction of the court, and when you're doing another thing, well, you're acting under the special jurisdiction created by the Constitution and by the National Assembly Validity of Elections Act. Now, Your Honor.
Also, Mr. Mendes, just to help me understand, to be clear. So you say one code, but that code from as far back, let me just see, since the 1961 order it appears, that code, actually no, yes, the 1961-64 order, that is sections 37 and 41 at that time. That code incorporates both the House of Commons and ordinary practice and procedure of the courts insofar, let me just use the word contextually then. Is that what you are saying when you say one code?
As of 1964, before the Court of Appeal was created, these regulations which governed whatever elections were being held at that point in time, because I think it was in 1964, but then friend Mr. Nandal, I'm sure will correct me, but it was in 1964 that you had a legislature to which you could be elected. And therefore, these regulations came into being. I think it is the 1964 order that provided for elections to an assembly. And then these regulations came into being governing the challenges to the election.
But what I'm asking you is, you say it is not bifurcated, but one code.
Correct.
But what I'm trying to just clarify for my note is, by one code you mean one code as provided for by the Validity Act and rules, including their incorporation of the House of Commons practices and the ordinary practices of the court, as per sections 37 and 41 of the since 1964. That has what you've traced for us is that first emerges in 64, and that one code continues until now, the 80 Constitution, but that one code that you speak of is a single code that includes the section 163 of the Constitution, the Validity Act and the Validity rules, as well as, where contextually relevant, the House of Commons practices and the ordinary practices of the courts. Is that what you're saying?
That is correct, Your Honor. So that the point is that it is the same High Court that adjudicates on non-election disputes, that is adjudicating upon election disputes. It's the same High Court, it's the same people, the same judges, vested with the same powers and the same appointments and instruments, etc., who are hearing the different types of disputes. But when we speak about a special jurisdiction or special court, or sometimes we use the shorthand election court, we are referring to the High Court exercising this special jurisdiction governed by a specific code. And the specific code includes Section 38, what is now Section 38 was Section 37 in 1964, and the powers that is granted to that court when exercising its election jurisdiction by Section 42 of the Act. And it just simply says the court shall, and the court that they're talking about is the court hearing an election petition, because the Section 3 of the National Assembly Validity Act will have said any question referred to in Article 163(1)(a), (b), and (c) may, with respect to an election referred to in Article 62, be referred to the court and shall thereupon be determined by it in accordance with this act. And the court is the High Court. So the proceedings, the petition is to be referred to the High Court, and the High Court shall deal with it in accordance with this act. And this is the code that governs those proceedings. And part of the code that governs those proceedings will, of course, be Sections 38 and Section 42. And all Section 42 is doing is saying, when you are exercising this special jurisdiction, which is governed by this act, you have the powers that normally exercised by the High Court in ordinary civil proceedings. What that does is not to create or to determine.
Pause for a second. Because what you're saying there, I'm very interested in. So when technically saying that is nothing more than you have the powers that the ordinary court exercises in its ordinary jurisdiction. Fair enough. So where, for example, there is a rule that says, under the Validity Court rule, that a petition must be served, really access so, within 5 days. Well, no, sorry, I think 14, whatever it is, 14, 20 days, within a fixed time limit. And something is filed out of time. My question is, I know this appeal is about jurisdiction, so I'm not trying to shift and get into the merits. I just want to clarify something. Is it then that the election court exercising its jurisdiction qua election court has the powers that are normally exercisable and can extend time or bridge time? For example, I want to use the time issue because, of course, time is what this whole case is about. But I'm not for a moment trying to interrogate the merits of the decision of the Chief Justice. I understand that is out of bounds for this appeal, and I'm not trying to do that. So I'm asking a theoretical question, but using that because that is the subject matter actually of this appeal. Yeah.
Your Honor, with regard to the question of, specifically the question whether you can apply to extend time, the rules themselves govern that. The rules that have been made by Parliament and will be found towards the end of the National Assembly Validity of Elections Act, I think it is in Rule 9,
right,
govern
yes.
the question of the extension of time. But I should say that
Lord, I to interrupt. I lost some of Mr. Mendez's statements. I'm not sure if everybody else did. And I think that this is an important point. I'm sorry about that.
So at what point did you lose him, Mr. Jeremy?
Say again?
At what point did you lose him?
Just within the last 30 seconds or so. So he was responding to Justice Jamada.
Yes. Okay. What I was saying, Your Honor, Mr. Jeremy, is that the rules themselves in Guyana are made by Parliament and are part of the National Assembly Validity of Election Act, also provide for making applications to extend time. In certain circumstances, I don't have the rule before me at the moment, but what I was going on to say is that certainly in the Eastern Caribbean, questions have arisen as to whether the court has power to extend time, and questions have arisen as to whether the court can exercise the powers under the CPR, for example, to extend time. And those questions have been adjudicated upon. Of course, it all depends upon the applicable rules. In some cases,
so Mr. Mendez, I mean, I get it. If the validity act or rules provide for time and extension of service, they govern. I get that. So I'm not. Maybe it's a bad example on my part, but so forgive me for that. What I'm really trying to get at is when you say Section 42 is simply saying that the powers that are normally exercisable by the court are exercisable by an election court.
Yes.
Right. So I'm just trying to understand for myself, what do you mean by that? What do you mean by the powers? You mean the powers that are discretionary? I use the example of extension of time because that's a discretionary power, but it could be anything else, you know.
I suppose that we'd only be able to answer that question with concrete examples when it arises and we need to look at it.
All
right. In this particular instance, the power that we are speaking about is the power to strike out the petition.
Yes.
Because you have failed to comply with the rules. And Your Honors have answered that question in the case.
Thank you. Mr. Mendez, could you help me?
Yes, Your Honor.
Can you tell me whether in England there is an appeal against a procedural determination by an election court?
I do not know the answer to that question, Your Honor. I do not know. I would have to research it for you, but I do not know the answer to the question.
Then I guess we both need to research it.
Yes.
Yeah. Mr. Mendez, with respect to both 38 and 42, the Act says the court shall, subject to this Act and rules of court. Yes. Do you see those as the general rules of court, be they CPR or the old Supreme Court or High Court rules? And so there is that intersection, because as you said rightly, we could only look at the matter if there is a concrete example. And for example, should someone want an adjournment, surely the court has those powers to adjourn. So that should be an easy example. But it does appear to me, reading this, unless I'm reading it wrong, it's not just the rules made under the Validity Act, but the rules of court. So there's that intersection, that interplay all the time between the powers and the jurisdiction of an election court and of a high court. How do you look at that? Because I'm trying to make sense of how it is.
Well, the term rules of court, of course, is a broad one. And obviously it would include the rules that have been made and that are appended to the Act itself. question whether that phrase rules of court also refers to the CPR is a question that has been raised in the Eastern Caribbean and determined. And again, generally speaking, Donna, please don't hold me to this. I haven't looked at those cases in a long time, but generally speaking, the answer is it does not refer to the CPR. As a matter of fact, I think at one point in time I had argued that it did refer to the CPR because I was at the wrong end of a strikeout application because the time limits had not been exceeded. And the answer was it doesn't apply to CPR. Whether that is correct or not is another question altogether. But the point is that it all depends upon the particular act, whether rules of court is referring to the CPR and exactly which rule we are speaking about. But even assuming, for example, that rules of court there includes the ordinary rules of court, and the court says, well, yes, I have those rules of court available to me, and for one reason or the other, the court is called upon to adjudicate upon that rule, then we would be right where we are now. Would a decision on that rule, whatever it is, whatever its source, that does not involve the determination of a question under Article 163(1) of the Constitution, is that determination appealable?
Mr. Benders, I see you're going into the meat of your argument. Before you do that, just one simple question. You may not know the answer, but you had a lot of very interesting history to give us as to the Article 163. Before the creation of the Court of Appeal of Guyana, was there jurisdiction to appeal to whichever court? You said it may have been the federal Supreme Court, and was that also limited the way we are considering in Article 163?
No, the Article 163 came into being in 1966 for the first time. As far as my researches, my juniors' researches take us, what is now the Court of Appeal Act, and in particular Section 6, 2 of the Court of Appeal Act, was originally enacted in 1958 in the Federal Supreme Court Appeals Ordinance of 1958, which currently, Jonas, we can provide you with a copy of that, but the terms of Section 6.2 were, it was then Section 9.2, but the appellate court then was the Federal Supreme Court. And so therefore you could appeal to the Federal Supreme Court against decisions which were final. It's the same terms again. After 58, of course, the regulations, which are now the National Assembly Validity Act, came into being in 1954, at a point in time when, again, you didn't have the Court of Appeal of Guyana, and you didn't have a provision that was similar to what is now Article 63(3), saying what you can appeal to the Court of Appeal. So you just had the jurisdiction of the High Court exercisable in relation to those regulations, and then presumably, I haven't seen anything to the contrary, the Federal Supreme Court Appeals Ordinance would have applied, so that you could appeal against orders that are final. So I imagine that if a question arose then, before 1966, as to whether you can appeal an interlocutory order, then the court would have to determine whether the order was a final order or not, which is the question that the Court of Appeal of Guyana answered by applying the order test in this case. So that question would have arisen then. What my case is that all of that changed, all of that analysis changed once the 1966 Constitution came into being, and you had Article 71 specifying that you could appeal, but only in relation to certain matters. Or I should say, it doesn't use the word only, but it says you can appeal on these matters. and it did not include an appeal on interlocutory matters, even though at that point in time, of course, the framers of the Constitution would have been aware of the existence of the regulations, would have been aware of the time limits imposed, would have been aware that the High Court had the jurisdiction, the ordinary jurisdiction of the civil court under then Section 41 to dismiss the petition if it did not comply with the provisions of the regulations. And this is where I was taking you then, Your Honor, to what this court has said in Cuffy. Because what you said in Cuffy...
Mr. Mendes, before you go there, Section 42 of the National Assembly Act, what intrigued me was these words, as if, because it says, okay, the court has the same powers, jurisdiction, and authority with respect to any proceedings brought under and by virtue of this act, as if the proceedings were an ordinary action within the jurisdiction of the court.
Yeah.
So I read this as saying, well, okay, we borrowed those powers, etc. We place them in this particular code, but they are not there because of the normal jurisdiction. It's only as if they were. That's how I read it. Is that how you read it too?
Because the presumption is that the court is not exercising its ordinary jurisdiction. It is exercising a special jurisdiction.
Yeah.
So it's saying, let's make it clear, although you're exercising a special jurisdiction, because the act starts by saying that you must, the petition must be determined in accordance with the provisions of this act. So it is creating a special jurisdiction, but Section 42 says, well, listen, although this is not an ordinary, you're exercising your ordinary jurisdiction, you have the powers of the High Court as if it were an ordinary jurisdiction.
Okay.
So just to make clear, any other powers that you might have in relation to the exercise of your ordinary jurisdiction, you can exercise in relation to this special jurisdiction, of course, subject to the Act and subject to the rules of court that have been made. So that confirms, in my respectful submission, the finding which this court made at paragraph 44 of your decision in the Cuffy case, 44 and 45. And if I can just remind you, at paragraph 44, that the court had quoted from the judgment of the Chief Justice, de Pereira, in which he said, just about 6 lines down, it is also separate to the court's original jurisdiction given under Section 16 of the Constitution for the enforcement of the protective rights and freedoms. It is common ground that this special jurisdiction incorporates the court's inherent jurisdiction to protect it from abuse in its exercise of the jurisdiction, so that the case law is replete with decisions striking out election petitions on a number of bases ranging from failure to disclose a cause of action, substantial non-compliance with election laws, and vagueness to abuse of process. So that this court has accepted that the court is not exercising its ordinary civil jurisdiction. And you will see on the following page, in paragraph 45, that Justice Anderson's statements in Skerritt and before referred to. Justice Anderson restated that the exclusive and exclusionary jurisdiction of the High Court to determine the validity of elections by way of election petitions was essentially a parliamentary jurisdiction which had been assigned to the judiciary by the Constitution by legislation. It is a special jurisdiction, distinct and different from the ordinary civil or even constitutional jurisdiction enjoyed by the courts, but of course we can add the rider, but nevertheless you have the powers that the High Court would exercise in its ordinary jurisdiction. But it doesn't that provision, Section 42, does not detract from the main premise, which you find in Section 42, that the court and the court in this particular case was exercising the special jurisdiction vested in it by Article 163 of the Constitution and controlled, if you will, by the National Assembly Validity of Elections Act made under the Constitution. So that is basically to deal with the proposition that was accepted by Justice Appeal Gregory and advocated by my learned friends in their submission, that somehow we must think of the decision of the court as being one not exercised in its special jurisdiction that is governed by the Constitution and the National Validity Election Act, but it's that you basically step out of that special jurisdiction, you make a determination as to whether the petition is a nullity or not. And presumably, if you say it is not a nullity, then you step back into the special jurisdiction. So respectfully submit that that argument is now foreclosed by the decision of this court in the Cuppy case. But it then comes back to our major proposition, which is that, as you see in 1966 and continued in 1980, the framers of the Constitution addressed their mind to the question, what jurisdiction should the Court of Appeal have? And this is particularly telling in 1966, when the Court of Appeal is being created for the first time. And the then Article 83, which is now 123, says that the Court of Appeal shall have such jurisdiction and powers as are conferred on those courts respectively by this Constitution and any other law. And then you have 163 that is specifically addressing the Court of Appeal's jurisdiction in relation to challenges to an election, and it then identifies the matters on which you can appeal to the Court of Appeal. And knowing full well that you have a National Assembly's Election Act in existence that governs elections, knowing full well that the High Court has the power to strike out petitions for failure to comply with the time limits and so on, knowing full well that is a possibility, but not including among the list of the things that the Court of Appeal has jurisdiction over, a jurisdiction in relation to, broadly speaking, interlocutory matters. It does speak to certain interlocutory matters, but those are those interlocutory matters in Article 163(3)(a) only. And if I may add my 2 cents worth to the discussion between Justice Jamada and Mr. Nandlal as to what 163(3)(a) means. Now, of course, Your Honors, I puzzled over that provision when I first saw it, because I then asked the very same question that Justice Jamada is asking: where is the provision that requires you to apply for leave? And there is in fact no provision that requires you to apply for leave, as, for example, the Trinidad and Tobago Constitution does. There's a provision requiring you to make an application for leave in the Trinidad and Tobago Constitution. It seems the framers of the Constitution assumed that there was a requirement somewhere that you apply for leave. And they then said, well, if leave is refused or if leave is granted, you have a right of appeal to the Court of Appeal. And of course, that would be consistent with B of the Constitution, because at the stage of applying for leave, you are not required to meet any time limits as yet. The time limits only apply when you file your petition. Having filed the petition, then you are on the clock, as it were. So that at the stage of leave, the court would be, in a sense, determining whether, as you do in judicial review, whether you have an arguable case or not. But it is, strictly speaking, an interlocutory matter, at least applying the application test, because at that stage, there's no guarantee that it will be brought to an end one way or the other, because you either could grant or you could refuse leave, as the case may be. So that at that stage, obviously Parliament has decided we are granting right of appeal because leave one way or the other is going to be determined on its merits there. Do you have sufficient to challenge to challenge the validity of the election on the basis of whatever is put before the court? And so therefore consistently, Parliament then provides in B for appeals when the court eventually answers the question as to validity one way or the other, thereby excluding appeals on any question not having to do with the merits. We respectfully submit. Now, Your Honors, of course, that provision is different from the Dominican provision that you considered, because in the Dominican provision, they say that you can appeal final decisions on the merits and no other decisions. Our provision doesn't say and no others, doesn't say that. And for that reason, Justice Appeal Gregory said, well, you can't imply the limitation on the Court of Appeals jurisdiction. It has to be expressed. And our respectful response to that is, Court of Appeal does not have any implied jurisdiction. It only has a jurisdiction that is given to it by the Constitution or the law. And we say that the framers of the Constitution, having addressed their minds to what jurisdiction the Court of Appeal should have, defined that jurisdiction in Article 63(3) and did not include interlocutory matters, and therefore the Constitution is to be construed as not permitting appeals on those matters.
So,
now,
Mr. Mendez, I understand what you're saying. So, but what I just want to tease something out a little bit with you. So that 163(3)(a) provides an exception to the practice policy rule that interlocutory applications are not appealable under the applications test, because that right? Okay. Because on an application for leave, either the grant or refusal, you can appeal. That is almost a that's before you even start the process. You haven't even reached service or anything now. So that we say that one of the main reasons justifying this strict approach, is of course expediency. Election petitions mustn't take long. We must get them heard and determined. Hence, this approach to interlocutory decisions. But they've created an exception where on the leave application, you can go all the way to the apex court and then come back down. Do you think it would be desirable for clarity and to achieve the objectives of what we chatted about, the policies we spoke about, that there is some sort of statutory regime that would underpin what is, it appears in practice, a very integral part of the process, and also a part of the process that can admit to an appeal and therefore delay, etc., to the determination of who should govern a country. Well, in this case, govern Guyana. Do you think, I know that that's not the subject matter of this appeal, I understand that, but do you think that there is a value in, I don't want to say like in Trinidad, because I don't know that the Trinidadian position is a model, but I suppose, yeah, let me stop at that. Yeah, do you think there's a value in that?
Well, of course, Your Honor, they certainly to make things clear so we don't have to tease out of silence exactly what has to be done. So that certainly Parliament should pass a law under Article 163(4), regulating the application for leave, just simply to make things clear, so that we don't flounder about and waste time determining exactly what is to be done. Certainly, I imagine at some point in time, somebody might just file a petition and not apply for leave, and then the question would arise, are you out of court because you didn't apply, even in the absence of a provision saying that you must apply? So clearly it is desirable that you have that clarity. But if I may just make one slight gloss on the point that you made about being able to appeal the refusal or grant of leave to right up to the apex court. And it is this, that of course the test for leave will be, I imagine, the test that has been adopted in relation to leave for judicial review, which is to say that the threshold is low and it's just an arguable case that you have to meet. So that in itself would discourage appeals, certainly appeals past the second tier court, because the test is low. So I imagine it is only in cases where there simply is no arguable case at all that you might find applications going right up to the apex court. But if I can remind you, Your Honor, that in Trinidad, in the last rounds of election petitions, and Your Honor, Justice Jamada, you were on the Court of Appeal in Trinidad and Tobago at the point in time when there was an appeal against the grant of leave, and I do believe that process was determined in very short period of time, and we went back to the petitions and some very complicated factually petitions that were also determined within a relatively short period of time. So it is possible.
Well, Mr. Mendes, you see that is a bee in my bonnet. Yeah? This argument that these things delay, in my opinion, delay is delay that is allowed by a court. Eh? And if expedition is a standard that courts must meet, then I don't see that the fact, I'm not suggesting that this is, I mean, I accept how we must be governed, but I do not accept that the fact that you have an appeal means that leads to delay. Any matter can be heard and determined expeditiously. It takes judicial will to do that. And the chair of this panel has already expressed some comments on that, and so I'm not going to say anything more, but I take the point completely, and as you have explained, I have been in that and done it, in which there were full-fledged, full-blown appeals on all kinds of complex legal issues that went up and down the ladder a few times, and maybe not ideally, but they were dealt with great expedition, I think. So
yes, my lord, but I think that the point that the court made in the Coffee case, when this court said that in construing the Constitution, you must construe it against the premise that the proceedings are to be heard expeditiously, is not necessarily that whatever proceedings come before the court will be delayed, but that if you allow appeals on the interlocutory matters, then that, even though they may be determined expeditiously in and of themselves, that would delay the hearing of the merits of the case. So that if you have a determination on the question of whether you have served on time, etc., and that now has to be determined to the Court of Appeal and then presumably to the apex court, then however long that takes, whether you manage to get that done in a month or 2 months or 3 months, as the case may be, as an outside period of time, then that is 3 months away from determining the merits of the matter. So that the policy, and I think this is what the court said in paragraphs 44, 45, and 46 of your judgment in that case, is that in interpreting the Constitution, you interpret it against the backdrop of the policy or the general approach that there are no appeals in relation to these interlocutory matters because they delay the eventual outcome of the election petitions, and therefore you leave the validity of the election in doubt for an extra period of time, however long that may be. And the court at paragraph 46, if I may remind you, Your Honor said, what is evidence from the abundance of jurisdiction is that the idea is to discourage, if not eliminate altogether, appeals on points of practice and procedure, and to render unappealable the trial judge's interlocutory decisions relating to failure to disclose a cause of action, substantial non-compliance, etc. And what I'm respectfully submitting is that is the idea that the framers of the Constitution had in mind when they enacted Article 71 of the 1966 Constitution, which is now Article 163, limiting the jurisdiction of the Court of Appeal to those matters that are listed in 163.3. They had in mind that appeals on interlocutory matters ought not to be allowed. Only these appeals ought to be allowed, and that is how they proceeded. And we therefore respectfully submit, adopting the approach of the court in the Coffee case, we interpret the intention of the legislators in enacting Article 163 as intending to limit the jurisdiction of the court to those matters and no other matters, even though they didn't actually say and no other matters. But that is implicit in Article 163.3, these questions and no other questions. But I say further, Your Honors, that even if we are permitted, even if the Constitution permits us to look at the Court of Appeal Act and to ask the question whether this appeal falls under Section 6.2, that is to say, whether it is a final order that's being appealed against, then this court has also answered that question. Because
yeah, Mr. Mendez, I don't think you need to trouble us with that. I think we know I think we delivered coffee just a few weeks ago. I'd only want to add that even as you quote coffee, it's not relevant to this case, that it's insofar as saying it limits the appeals to the 163.3. In coffee, we have reserved a certain area of constitutional impropriety for which in election petitions there can be a review. For example, the fair hearing and or if there are any other egregious constitutional breaches. But we do say that those are, strictly speaking and technically, not, how to put it, they can exist independently of the framework of election petitions and fall under the broader constitutional requirement of compliance with the rule of law and the constitutional guarantees, etc., etc. So just to say that in coffee, I don't think we limited appeals to the 163.3 in that bald sense. I think not applicable to this case, but we do a little bit more.
Yeah, yes, and I was going to, I had asked my learned junior here to remind me to raise that point. And it is in relation to the question that Justice Witt had raised. What if you have a rogue judge who completely misapplies the law? Then the answer to that is that this court has already recognized that possibility by creating that exception or the possibility that what has happened is not a trial at all. You did not get a fair trial. You were not protected by the law because the judge just simply went rogue and decided something that was not before him or her, as the case may be, or simply decided it on the basis of no evidence whatsoever, or something of that egregious nature that constitutes a constitutional violation. And that exception is always there to deal with the concerns that have been expressed. But the point is, Your Honors, that as my little friend Mr. Nandla has pointed out, it is not unusual to make provision that the decision of the High Court judge is final and that there are no appeals at all. And I suppose you sacrifice, in those circumstances, you sacrifice a well thought out ultimate decision by more than one judge on the altar of expediency and swiftness. But that is not our case here, because the fundamental questions that the court is required to determine, that is the validity of the election, that certainly is subject of an appeal right up until the apex court. And therefore, the other answer to the concern, Your Honors, is this: that the election petition is not for the election petitions are not for the faint of heart and not for the amateurs. The Act says what you must do, and it's not cast in difficult language. It says what you must do. Just do it, and these questions simply do not arise. I'm sorry to put it
which is the Attorney General is here, which is why I hope that there can be something intervention to clarify the process at 163.3a, because the law says that anybody who is an elector can challenge, and so that yes, it is not for the faint-of-heart, but it also ought not to be that it must require some sort of sophisticated professional experience. The system for the challenge elections should be made clear, transparent, and accessible for the ordinary person, so that Honorable Attorney General is here, and I hope he thinks about it, because I really think that it aids democracy if what has to be done is laid out clearly, simply, in plain English, and anybody could pick it up and say, okay, I want to challenge the election. You may lose at the first hurdle, that's fine. But at least you need to know, look, I need to get leave. To get leave, I need to do A, B, and C. This is the form that we prescribe. That's not hard to do, but it means the ordinary citizen could pick it up and know what they can do. When we say on one hand, the elections are the lifeblood of a democracy, and then we make it so opaque, I don't think that is an aid to democracy. Not the subject matter of this case, but I'll just leave it at that.
In honest, I have, having been at the wrong end of strikeout applications, I share that. I certainly share that, or I should say, having been at both ends, I certainly share that sentiment. But as you have acknowledged, we're dealing with the law as it is at present, and that is what we have to. Of course, I'm sure the Attorney General is hearing what you have said. And if I may point out that in the Eastern Caribbean, rules have been made by the Chief Justice governing election petitions, and there are provisions for applying to extend time and that sort of thing. So that I suppose experience has, and of course we also have rules in Trinidad now arising out of the Gypsy and Chaitan case that govern the election petitions that are written in simple language. Not that the rules in this case are not clear either, but there are rules that tells you exactly what you have to do. There you are. That's where we are.
Maybe they could be made a little clearer. From your point of view. Point taken.
So that essentially is the submission on behalf of this appellant, Your Honors, unless there's anything else that I can assist you with.
Just a small issue, Mr. Benders. I just wondered, coming out of the conversation between you and Justice Jamada, whether the framers ever thought that all these except one or two election petitions will be dismissed on preliminary applications to strike out. If that was what, or did they really think that persons would settle down and look at the merits of the case? Just a thought, because this is not the first time that we're hearing that so many matters are being dismissed.
But Your Honors, I don't know. Again, I don't know Mr. Nandlal, of course, knows the history of election petitions in Guyana. But certainly election petitions in Trinidad have been heard on their merits. Election petitions in Antigua that I participated in were heard on their merits in St. Kitts and Nevis, and you would have seen some of the judgments in those cases where there were trials and all of the evidence came out. Cayman Islands, and in other words, it's not all doom and gloom. There have been many cases in which they have been dismissed on the basis of failure to comply with the rules. But there are also cases throughout the region. I'm using the region, of course, because this is your catchment area, in which petitions have gone all the way and to the Court of Appeal on the merits. Dominica was one of them. For example, there was a petition that went. There was a challenge to the now Prime Minister on the basis that he was a citizen of France, and that was heard on its merits, and it went to the Court of Appeal on its merits as well. That's another example.
Okay, thank you very much, Mr. Mendes. I see it's now 12:38. Our schedule was actually, well, it had a break after Mr. Jeremy would have spoken. That would have been at 12. I was wondering because this is going to be somewhat longer than we expected. If we want to continue or if we take a moderate lunch break before we continue. Mr. Jeremy, let me ask you first, but I will have to ask my colleagues too. What do you propose?
My lord, I favor taking a lunch break. It's not because I am particularly fond of eating, but at my age, I try to observe a particular regimen. So with the indulgence of the court, I would appreciate a break.
Okay, could we take half an hour?
Fine with me.
That would be fine, colleagues? Yes, okay. So,
Chair,
yeah, sure.
can we come back at, is it then 1:15 would suit you?
Yes, 1:15, that seems like a good time.
Okay.
And then you will have the floor, Mr. Jeremy.
Thank you, my lord.
Okay, so we adjourn till 1:15. You can stay on the platform. You can close your microphones and video cameras, and we will be back at 1:15.
Thank you very much, Your Honor.
think we can resume.
Yes, Justice Smith, we can. Thank you.
Okay.
I am not seeing Justice Anderson as yet. Judge, are you there?
Yes, Madam Deputy Registrar, I'm
Okay.
very much here.
Okay, thank you, Judge. Sorry.
Thank you. Okay, Mr. Jeremy, I think it's your turn now.
Thank you, Mr. President. Mr. President, the appeal which is before the court this afternoon has its genesis in a preliminary objection taken by the appellants to the exercise of the question of jurisdiction of the Court of Appeal to hear and determine an appeal in certain circumstances. Now, I say that at the outset only because of what was said this morning about the need to have these, and this is my word using some of the other decisions, in particular Justice of Appeal, Chief Justice De La Voisin, as he then was, to avoid fragmentation and to promote expedition in election petition matters. So my learned friends took a preliminary objection. They didn't wait until the appeal was heard. They took a preliminary objection that was open to them to the exercise of the jurisdiction of the Court of Appeal to hear and determine the appeal, and that objection was based on the following circumstances. At first instance, you would recall that the Chief Justice had struck out the petition on a procedural ground, so that she had dismissed, the Chief Justice had dismissed the petition on the ground that it was a nullity. She held that it could not be maintained for non-compliance with what she determined was a mandatory rule as to service on the second defendant, David Granger. Now, in Guyana, as my learned friends discussed at length this morning, the first port of call in looking at the jurisdiction of the Court of Appeal in determining appeals is Article 163 of the Guyanese Constitution. Now, I won't read the section or the article, but the article begins by the scheme of the article is such that in 163.1, it provides for certain defined instances in which a high court has jurisdiction to overturn the petition. And in 163B, which links into 163.1, the Constitution provides that an appeal shall lie to the Court of Appeal from the determination by the High Court of any such question. So you have those words, any such question, and then it goes on, or against any order of the High Court made in the consequence of such determination. The appellants argue that the Court of Appeal lacks jurisdiction to hear this appeal because the appeal is from a decision that does not determine any of those matters set forth in Article 163.1. That's the first basis, that's the first string to their arrow. The string to their bow. The second string is that because the striking out by the judge was for a reason outside of the matter set out in 163.1, there is no right of appeal. So what they urge on this court is an interpretation which runs as follows. Because Article 163 does not expressly state that the jurisdiction of the High Court is a final jurisdiction in matters set out to be appealable, that some reason or the other, you link 163.3 to 163.1 and you gather some sort of prohibition against the Court of Appeal assuming jurisdiction in a matter like this. Now, the appellants in the court below and in this courts say by way of a preliminary objection that the Court of Appeal lacks jurisdiction to even hear the appeal for that reason. They say that there is no implicit jurisdiction, and then they say that there is a policy reason. This runs throughout their submissions. A policy reason for determining these matters quickly, and no one can doubt that. And that policy is given effect to in the structure and terms of Article 163. Now, if I can take the last one first, the policy. The rule of law argument, which is that citizens should have access to justice, should be able to question the validity of the elections, that we urge to be no less worthy of value than the value of having a speedy resolution to the questions of membership of the legislature. And we say that notwithstanding the fact that there are a number of cases which trumpet the expediency policy. But we say that in Guyana, if you look at the terms of the Constitution and the legislation, and also the practice of the Guyanese courts, Esther Pereira was a case in which, after 5 years, the court held that the election had been wrongly, the election was void. It had to be done over again. So they place a high premium in Guyana, in the courts of Guyana, on the rule of law principle. That is to say, citizens should have access to the courts. Citizens should have access to the courts to complain about an election that is not fair, and that is something which ought to trump or at least be measured equally in the balance in terms of assessing the premium to be placed on the policy of expediency. Now, the Court of Appeal held that the appellants were wrong, that it was open to them, and they didn't actually say this, but I imagine, to await the appeal itself. They did not. And they elected to appeal on the basis, and this is all self-inflicted delay on their part. They elected to appeal only for the reasons that I have articulated. As I say, nothing would have been lost if the appeal had awaited, if this appeal had awaited a fuller appeal on the entire question. Now, we accept that the powers of the High Court are limited by, and we must, limited by the Constitution and by the legislation which creates this jurisdiction. And of course, there are several cases on point I'd mentioned too, Petrie and Christopher Ram. The determination to dismiss the petition without a determination of the merits, they say, could not be appealable because on a construction of Article 163, no other appeals outside of 163 appeals could go. And they argued in support of that contention. They urge the court to accept the fact that Article 163 was the only route, that's what they say, the only route to the Court of Appeal on these facts. 2, Article 163 provided for jurisdiction in respect of matters specifically set out therein. We have no problem with the second one, we have a problem with the first. And 3, that the fact that only appeals in those matters set out in 163 could be appealed necessarily meant that nothing else could be appealed in respect of election matters. And we have a problem with that. And obviously the Court of Appeal had a problem with it. And it's not consistent with the jurisprudence in Guyana as well. So we say it was wrong to allow the courts in principle to use its powers of appeal to deny it the ability to use its powers of appeal contained elsewhere when Article 163 governed the appeal in certain specified circumstances. Now, if you read Article 163(3), that is the provision to appeal to the Court of Appeal, that is to be read in light of the provisions of the Constitution itself. And the Constitution must be taken, we say, as a whole, and it includes section 123(1) of the Constitution. More on that in a while. I return to that point. This instant appeal concerns an application made outside of the strict confines of Article 163, in the sense that because the basis of our complaint was a matter which was not explicitly set out in the heads of 163(1), then 163(3) would they say not have allowed the appeal? Now, we have a couple of problems with that. First of all, we argued in the court below that 163.3 should be given a wider interpretation that my learned friends sought to advance. And although we did not use the language of leave, which my learned friend, I'm sorry, it was not Mr. Mendez, but Justice Jamada spoke about this morning. We felt that there was room in that article 163 to allow for appeals in circumstances where there had been what was analogous to a refusal to treat with the application to treat with the petition at all, which would have been analogous to the rejection of the case on the basis of absence of leave. But in any event, we had other arguments, and the Court of Appeal did not find for us on that sort of argument. They argued a basis other than Article 163. This is the Court of Appeal. They felt,
Mr. Jeremy.
Yeah.
Just for my edification, where is it in 163 that you were proposing to locate the right of appeal? As you said, the Court of Appeal did not see it your way, but you're advancing that ground before us. So where exactly are you referring us to? Because when I look at the various items in 163.1, it is not immediately obvious to me where it is that you are proposing that the right to appeal resides.
Okay, so we were arguing, I'm not sure that we put the matter as in the way that we did not put the matter in the way that Justice Jamada did.
Yes.
But we were arguing that the language in 163.3 allowed the 163.A, where you have the power of the judge to grant or refuse leave to institute proceedings for the determination of any question referred to in paragraph 1, that would create a situation where the Court of Appeal would have a jurisdiction which is analogous to, and I'm not sure that this is the way the argument was actually framed. I did not argue the case in the lower court, so I was listening to my learned friend, Mr. Ford. But the argument, as I understood it, went like this, that you had certain exceptions. At the time, the constitutional exception that you have no hearing because the judge had done something egregiously wrong, but that there was a statutory exception here, and that it could be argued that the refusal to the agreement to strike out the petition was analogous to a judge granting or refusing to leave to institute proceedings. As I say, it was one of our arguments, as the Court of Appeal did not agree with us.
Yes. Well, thank you for that, because I was having a difficulty myself identifying where that argument would find ground. when I look back to paragraph 1 and the questions enumerated there.
Yes.
I do take your point that you're arguing by analogy, and once you do that, then all bets are off, I suppose. But I just couldn't find the specific ground there. But as you say, you didn't stress that too much, I gather.
No.
In your, yeah, okay, good, thank you.
We lost on that, but the Court of Appeal found, of course, we agree with what the Court of Appeal found.
Yes.
Notwithstanding that there were a number of other routes available to them which would allow them to have jurisdiction in this matter. And I recommend to your lordships the decisions of the Chancellor in particular and of Justice Gregory, Justice of Appeal Gregory. Now, what they did was to look at the question by way of the jurisdiction of the Court of Appeal. First of all, they said they admitted, as they had to, that the jurisdiction of the court in election matters was a special one. But, my lord, you would know that, I'm sorry, my lord Anderson would know that in the case of Marin versus the Queen, he uttered these words. Just repeating them, I know that time is of the essence. He says there that at paragraph 7, referring to Marin and the Queen, says these express constitutional and legislative provisions are not necessarily exhaustive of the provisions on the jurisdiction of the Court of Appeal. It will be recalled that Section 101 of the Constitution specifically provides that the Court of Appeals shall have such jurisdiction and powers as may be conferred on it by this Constitution or any other law. And it was in that context, I imagine, that the learned Chancellor and Justice of Appeal Gregory embarked on an analysis as to whether or not, and I disassociate myself completely with the language of one of my colleagues this morning in saying that there was a valiant and desperate attempt to find a jurisdiction. I think that, I'm not sure if that was direct. I was hoping that it was directed to us and not the court. But the court did a balanced job. It looked at the authorities, and it said both Justice of Appeal Gregory and the Chancellor said that they found such a jurisdiction, a general jurisdiction, in the words of in the language given in the Court of Appeal Act. Now, of course, the Court of Appeal Act only allows for appeals in certain circumstances, so you have to vault hurdles there, and those hurdles with respect were not present in the Coffee case, which this court decided. So you have to interrogate the question, what is a final order? Because the Court of Appeal Act is premised on appeals from final orders. And in Azu versus Arthur, the fact is the case decided that the petition was defective, dismissed the petition on a procedural matter, but it held nonetheless that that decision in an election petition, even where the matter has not proceeded to the hearing of evidence, is one that they would take countenance of. That is to say, it was a final order. Now, there are other cases. There's I won't repeat some of these cases I mentioned.
Mr. Jeremy, can I just interrupt you for a second? I just want to follow the last point. This decision is at what level in Guyana? Court of Appeal?
That's at the Privy Council, as I understand.
And this is a Privy Council, but it is not from Guyana then? This is a PC decision?
From Guyana.
From Guyana.
It's from British Honduras, my brother.
British Honduras. I wondered where British Honduras was and what it was.
And in that decision...
Overtaken by Belize now, Mr. Jeremy.
Belize. Yes.
Right. And, well, our brother should know, shouldn't he?
Exactly.
In an election petition, so this was this an appeal that went to the Privy Council in which it was a procedural appeal that went to the Privy Council? Is that what it is?
Yes, my lord, but might I just be allowed to complete and come back?
Yeah, no, I was just trying to get a context.
Okay.
Sorry, Mr. Jeremy, before you go further, perhaps it would help, especially in the context of the disquisition presented by Mr. Mendes this morning very helpfully, that at the stage when Arzu and Arthurs was argued, appeals went from the High Court, which was called the Supreme Court, to the Privy Council. We did not have a court of appeal.
Yes, I listened with great interest to Mr. Mendes' description of the history. I did. Might I just, I wouldn't be long. I promise, Justice Jamada. I know that you always have...
No, you go ahead. I won't forget what's in my mind, so don't worry. You go ahead.
So, the Court of Appeal noted in just a second. There's another case, A.G. and Peters, which had a different result. But in that case, the Court of Appeal noted that the use of the expression final under Article 103, subsection 3, does not, well, is what they said, I don't want to put words into their mouth, is not expressed in terms which exclude appeals other than those which determine questions in Article 103.1. Is it 103.1? I'm not reading my eyesight is rolling. So the question which the Court of Appeal had to deal with after they found, as I said, they found against us on the 163 argument. They then turned their attention. The Chancellor said, "That's not the end of the matter. I want to see if there is any other jurisdiction which I have, or which I might have." And it was in that context that she turned her attention to the Court of Appeal Act. And of course, in the Court of Appeal Act, there is this qualification on whether the appeal is final or not. So she examines the cases exhaustively, and she looks at the Guyanese cases in particular. And although she is reticent to say, listen, I'm applying the order test instead of the application test, because as opposed to Justice of Appeal Gregory, who says, I'm applying the order test. But the Chancellor is in two minds. She says that on either approach, the result would be the same. Now, the point to remember is that after examining the authorities, Justice of Appeal Gregory held, going back to 163, that the framers would not have left finality, because remember, 163 says, an appeal shall lie in respect of these matters in 163.1. That's 163.3. It doesn't say that anything you do, because the appellants wish to have their cake and eat it too. They don't want to make a decision. The decision is not made inside 163.1, and therefore they say it can't be appealed. It's in their interest. If they said it was made in 163.1, be subject to appeal. But Justice of Appeal Gregory says that no, if it's made outside of the context of 163.1, I have to look to ensure that there is no other basis on which I can assume jurisdiction, because she says, and the Chancellor and Justice of Appeal Gregory say that my first duty is to determine whether I have jurisdiction. And she says quite properly that the framers would not have left finality, and that's an important thing. Finality, as you know, shuts out scrutiny. That's anathema to the rule of law as a general principle. It could be that there's a contravening policy, expedition, but in Guyana, that is less the case. So she says that the framers would not have left finality to be inferred, dealt with by implication, but would have made express provision for it. And they did not. So what her conclusion is that, looking at the Constitution as a whole, and looking at the provisions of the Court of Appeal Act, she is only going to look at, she found, as I say, she found against us on 163. So she's looking at the question, do I have jurisdiction under anything else? And there are broad powers in the Court of Appeal Act, which are circumscribed only by the question whether this is a final appeal within the terms of ASU, which is the case that I mentioned a while ago, and which I know that Justice Jamada is waiting to excoriate me on. But and she says that within the terms of ASU, it is final because, as the cases say, it is the alternative argument would be to argue interlocutory to what? This brings an end to the proceedings. So she holds that 163.1 is in essence an additional jurisdiction to hear election disputes, which does not exclude the exercise of the ordinary jurisdiction of the court to operationalize the additional jurisdiction of Article 163. Now, I just pause there to make the point that it's common ground that when the Chief Justice dismissed this petition, she dismissed the petition. I mean, they say that the petition was dismissed for matters not expressly stated in 163. And that is not dissimilar from what Justice of Appeal Gregory is saying. That yes, you look at 163, but it has to be seen as my learned friend, I think it was the Attorney General was saying, it has to be viewed in context. And the context is that there is a provision in the Constitution, 123, that there is a provision in the Court of Appeals Act, Section 6, subsection 2, and that there is the conjoint effect of those and other provisions is to deem that the High Court has certain powers and rights to deal with matters on their list. And the judge said, the Justice of Appeal said that this judge, at first instance, the Court of Appeal judge, was exercising a power not in Section 1, Article 163, but a power which she had, an inherent power which she had to clear items from her list. Now, you can't have your cake and eat it too. You can't say that that is what she was exercising, and that, because that is the thrust of their argument is that, well, she didn't exercise the power in 163. Yes, but she didn't exercise the power in 163. She exercised the power outside of 163. Does that mean that she's protected by the scheme of 163? And the Court of Appeal says no. So, my lords, there are a number of cases which the Court of Appeal uses, including Chung and Campbell versus EIC, which is a decision of the Court of Appeal on the order test in Guyana, where the order brings an end to the proceedings. It could not be said to be interlocutory. And then there's that dicta from Duport and Freeman, interlocutory to what? And those cases were properly applied in our respectful contention by the learned Chancellor and the learned Justice of Appeal. And for those reasons, we ask that this preliminary objection to them entertaining this matter be dismissed. Thank you, my lord.
Yes, thank you very much. As we have no further questions, I think I should go back to the Attorney General for a reply.
Thank you very much, Your Honors. Questions were asked, Your Honors, in relation to Section 42 of the National Assembly Validity of Elections Act. And I made reference to my Court of Appeal submissions and specifically to the dicta of Chief Justice Chang, as that issue was raised in the matter, the extent of that Section 42 jurisdiction. And if I may share that briefly with the court, this is what Justice Chang said. After quoting Mr. Ford, he says, Mr. Ford, on behalf of the first named respondent, has referred the court to Section 42 of the National Assembly Validity of Elections Act, which provides, and then he quotes it. Thus argues Mr. Ford, subject to the provisions of the National Assembly Validity of Elections Act and the rules of court, presumably made by the Constitution itself, the High Court has the same powers, jurisdiction and authority with respect to election petition proceedings as it has in ordinary proceedings. But no act of parliament can enlarge a jurisdiction and powers conferred on the High Court by the Constitution unless the Constitution itself contains what has been called a disentrenching provision. Article 164D empowers Parliament to make provisions respecting the practice and procedure of the High Court, but only in respect of the exercise of the exclusive jurisdiction and powers conferred upon it by Article 163(1). Thus, it does appear to the Court that Section 42 of the National Assembly Validity of Elections Act must be strictly construed as conferring on the High Court the same powers, jurisdiction, and authority with respect to procedural matters and matters of practice as are possessed by the High Court in an ordinary civil action, but only in respect of the exercise of its exclusive jurisdiction conferred by Article 163(1). Section 42 of the National Assembly Validity of Elections Act must be construed in the context of Article 163(1), since Article 163(4)(d) enables Parliament to make provisions in respect of practice and procedure of the High Court, but only in relation to the jurisdiction and powers conferred upon it by this article. The practice and procedure in respect of which Parliament is enabled must therefore relate only to the exclusive jurisdiction of the High Court to determine the question mentioned in Article 163(1). Section 42 of the National Assembly Validity of Elections Act therefore does not support the first name contention, since it does not open itself to the wide construction which appears on its face. It is contextually limited in its application. So, Your Honor, I believe my learned Senior Mendez has put forward the same argument. So it is within that context.
Honorable Attorney General.
Yes, Your Honor.
I'm sorry to cut you in mid-stride, but you will be making that piece of information available to us that you just read out?
It is on the record, Your Honor.
Can you remind us where?
It is on the record. My submissions that are before the court in this matter refers to my submission in the court below in the footnotes. And they're all part of the record.
Okay,
so this
we'll find it. Thank you, sir. Thank you.
This extract, Your Honor, is taken from Ganga Prasad against the Chief Elections Officer, a 2015 petition. So what is clear here, Your Honor, is that the judge sitting in an elections court or hearing an elections petition and in exercising that special jurisdiction also is exercising the powers that a judge would have to protect the court against abuse, to subpoena witnesses, to summon witnesses, to adjourn from time to time, to exercise powers of contempt, etc. That is what Section 42 speaks to, Your Honor, nothing else. Then, Your Honor, reference has been made also to the absence of the limiting words or finality clause in Article 163 of the Constitution, in particular by Justice of Appeal Gregory, and my learned friend just referred to it. And it is from that the Honorable Judge, Justice of Appeal, eked out a jurisdiction by way of implication. I have made copious references to authorities that say, traditional authorities that speak to the creation of a right of appeal by statute. But there's a very useful passage which appears in my submission at page 14, that's 2027 of the record, and it's an extract from a Court of Appeal decision of England, and it says this: there can certainly be no implication of a right of appeal. I repeat respectfully for emphasis. There can certainly be no implication of a right of appeal. Questions as to which methods for determining rights are the most desirable raised issues of policy which are for Parliament to decide. But courts cannot invent a right of appeal where none is given. The courts will not usurp an appellate jurisdiction function where none is created. And I say, Your Honor, with the deepest of veneration, that is what the Court of Appeal did in this case, and that is what the Court of Appeal of Dominica did not do in the Dominican case of Coffee and Scarrett, a position upheld by this honorable court. Your Honor, the other issue that I would like to briefly touch on is Article 163, 163, 1 minute, Your Honor. 163, 3A. And to, perhaps I did it, and for the risk, with the risk of being repetitive, I just want to point out that here again, 163, 3A, here again, an appeal, a right of appeal is created against the scheme of the Court of Appeal Act, because here an appeal is being conferred upon what presumably is an ex parte order, and that generally, Your Honor, is prohibited in the Court of Appeal Act. I draw that to the attention of this court to emphasize the differential in the regime. Such an order as granted by this court, such an order made under this article ordinarily would not have been appealable. The point I am making is that there is two different regimes that exist. But to go directly to the issues that was raised by Justice of Appeal Jamadar, I found the case to which I made reference, and it is Melville, 2006 elections petition, Walter Melville. Again, the judgment of Chief Justice Chang. And Your Honor, one of the grounds upon which that election petition was challenged was that the leave to present the petition was obtained on an ex parte application, and therefore in breach of the rules of natural justice and in contravention of Article 163(3) of the Constitution. And I read from the judgment quickly. The second named respondent has admitted that the petitioner did obtain the leave of the court on the 16th of November 2006 to file the petition. So as I said in my previous presentation, this practice of obtaining leave has always been there. This is evident here in the 2006 matter. I did it in Ganga Prasad 2015, and respectfully, the petitioners in this matter did it. I will try to get the order and present it to the court. But I continue. While neither Article 163(1) nor Article 163(2), either expressly or by implication, prescribes that leave of a High Court judge must be obtained before proceeding for the determination of any question referred to in Article 163(1) are instituted, Article 163 clearly contemplates that such leave must be first obtained before such proceedings are instituted. So, Your Honors, Your Honor Jamadar is absolutely correct. That is the interpretation that has been placed on it. The question for determination in this petition clearly falls within 163(1).
Honorable Attorney General,
yes.
I raised this with Mr. Mendez, but since you're in reply and you are speaking to it, and the court has accepted, that is Changji, that the 161, 1 and 2 don't say that. I don't require a response from you, but I hope that to make our democracy more transparent in Guyana, that some form of,
I got
rules or acts will be laid out so that the ordinary person knows what has to be done and make it easy.
Yeah.
It helps democracy, Attorney General. I won't say more.
Yes, I appreciate that, Your Honor. I appreciate that. I heard Your Honor very clearly and loudly the last time Your Honor spoke, and it will be a matter that will be considered at the appropriate time. Your Honor, the other point that I want to emphasize is the position postulated by my learned friend that somehow an impression is being conveyed that the petitioners were denied protection of the rule of law when their petition was struck out for non-service. Your Honor, that is a very flawed argument. The petitioners under the rules were afforded the requisite time to serve their petitions, and they did not comply. And 100 years of authorities have uniformly said that when there are such procedural violations, then there are certain ordained consequences, and the authorities have uniformly applied them. Mr. Mendez made reference to faint heart, and perhaps that is an apt description that I'll use. So it's not the question about, the question therefore is not whether rule of law is available or they were denied rule of law. This is the dispensation to which they must comply. This is the statutory framework. And the policy considerations which underlie them have been discussed repeatedly right here this morning, as well as in many other cases. And I don't need to rehash them, but to convey the impression that something was, that some grave violation of unfairness occurred is wrong. Whatever the regime was, they were afforded time to comply, and they did not. And the learned Chief Justice, in her decision, have relied on all the cases relevant to justify, or not justify, but to give Her Honor's decision the judicial authorization that it required, supported by sound authorities dating back quite a number of years. So Your Honor, it is not right for my learned friend to say that somehow there was some abrogation of the rule of law doctrine.
But Mr. Attorney General, of course, when we talk about jurisdiction, that is an abstract concept. So it cannot depend on exactly the case that one wants to appeal. So there is, of course, maybe, and I'm not saying that that's the case at all here, but you have the theoretical possibility of an egregious violation by a first instance judge. And if I understand you correctly, then even that would not be, there would be no jurisdiction to deal with that in appeal. Because you have to look at not just the case before us, whether that might be a strong case or not, but if we say you, in a case where you have procedural flaws, or at least alleged procedural flaws, then that's a decision of a judge and you cannot appeal it. That means that even if it is totally egregious, you cannot appeal it, or would you see this differently?
Save that special place which Justice Jamadar so elegantly and elaborately expatiated upon in his judgment in the Coffee case, to accommodate, for example, an egregious violation of the Constitution, let us say, right to be heard.
Yes.
If in except one of those cases, then there is no appeal. Unless, so, and that doesn't exist here at all.
Yes, of course I also remember that kind of way out that the court contemplated in the Coffee case. But then you referred us to Article 133 of the Constitution of Guyana, paragraph 2.
Yes, Your Honor.
Those are appeals on constitutional questions and fundamental rights. And then you referred us to paragraph 2, saying nothing in paragraph 1 shall apply to the matters for which provision is made by Article 163.
And
does that seem to cut off that possibility that we contemplated in Coffee?
That, Your Honor, therein lies the scheme that I keep referring to. And I'm trying to be as accommodating and as flexible as I possibly can, but I have to deal with what the matrix is, as expressed in the statutory code. And that is why I have resorted to emphasizing that provision in my written submissions. And yes, there is the other point that I wanted to Section 38 of the National Assembly Validity of Elections Act, which refers to the subject to the act, the practices and procedure extant in the House of Commons, is a provision that has also been mentioned. But, Your Honor, neither of the two judges of the Court of Appeal referred to that as an avenue to found their conferment of jurisdiction. Neither has the respondents, the lawyers for the respondents, made any reference to any of those practices, whatever they may be, to ground a right of appeal in the Court of Appeal in relation to this matter. So we don't have anything, and I don't know of any of those procedures off the top of my head that will justify or create a vehicle to convey a right of appeal from the High Court to the Court of Appeal in these circumstances. So, Your Honor, I will rest on my submissions that are in writing, and in addition to what I've been permitted to say so kindly by this honorable court. And Your Honor, I will incorporate into my submissions the submissions that are before the court from me, both at the Court of Appeal, and there are two sets, my original submissions and my submissions in reply.
I thank you, Honorable Attorney General. I just wanted to make the point, and it's not really a matter for you to necessarily respond to, but you are on the call, and there are others on the call as well who may have influence in this area. I see Mr. Mendez, who practices in more than one jurisdiction. I know that Mr. Jeremy also is itinerant. It seems to me that we do have some areas in our electoral practices that we benefit from searching review. You have undertaken as well in Guyana to do what you can to look at some of these areas. It seems to me that the problem is much more widespread than just in Guyana. You know, we have had cases out of Dominica which have presented peculiar issues. In fact, I understand that a former president of the CCJ, Sir Dennis, is looking at forming that jurisdiction. I rather suspect that there are issues right throughout the region. And the question arises as to whether there, and I'm speaking out aloud here, I'm not asking for a response, there could not be some kind of regional examination or arrangements, because as they stand now, they really can be productive of quite strange results. As we have noted, the court has sort of carved out a possibility for an exception in extreme kinds of cases. But that has to do battle as well with the express wording in the Constitution. And therefore, it might be useful for us to begin to think about how we can tackle what is really a governance problem, governance issue, so that we can be sure that our democracy is worth the praise that is attached to it. But this, of course, goes far beyond this case and far beyond what we've been talking about. But I do think it's something that we should begin to think about various arms of government, the judiciary, the legislature, and the executive, and particularly, of course, those who can make the laws, to see how best we can tackle some of these issues, because they have the potential to really be quite problematic, you know. And we don't want to get to the stage where there is an extreme case, and then question is, well, what do we do?
Your Honor's,
Thank you, Chair.
Your Honor's sentiments are noted, and perhaps the Legal Affairs Committee of CARICOM, which is a body of the Attorneys General, we act upon the directions of the heads. So perhaps, well, that movement can begin with a political direction from the heads, and then come to the Legal Affairs Committee, and we have a common code that doesn't detract. I would not support one that detracts from the gravamen of the current jurisprudence, but one that fills the gaps, as Your Honors would have pointed out. That type of dispensation certainly is worth exploring, Your Honor.
Mr. Attorney General, I just, coming back to the case, I just had one question. You said normally there is no appeal against granting or refusing leave to start some procedure. Did I understand you correctly?
No, there is the appeal is created, a right of appeal is conferred by 163.
Yeah. But you were saying normally this outside 163.
No, it's not normally appealed. Leave is granted. Of course, a case has to be made out for leave to be granted, and that is explained in. I have another case that dealt with the issue, a Court of Appeal decision from Guyana, Stanley Singh against Esther Pereira. We have a Court of Appeal ruling where some component of that particular application went to the Court of Appeal, and we have a written judgment. But normally, of the petitions in which I have been involved, other than Esther Pereira, none of them went to the Court of Appeal. The leave was granted, and the application was made ex parte. In fact, the issue that Chief Justice Chang had to deal with, which he dealt with, was whether the application, which was made ex parte in Melville case, was wrong. And Chief Justice Chang, borrowing from de la Bastide in Gypsy and Chaitan, ruled that ex parte application was proper and appropriate because there was no express stipulation to make it inter partes. I think that was the ratio decidendi.
I was asking it because I could imagine that, let's say, you don't want to have too many appeals, even in leave decisions, because our procedures are dragging on already too much. So to save time. But then if that is the reason, then it's kind of remarkable that in 163.3a, it was contemplated that whether there's a refusal or a granting of leave to start this petition, you can appeal that, and you can appeal it up to the CCJ. So that seems to be somewhat in contradistinction to the idea that the system is structured to get things quickly done.
Well, again, it comes back to the threshold test, because there, what the policy of that provision, the intent of it is to weed out a case that is not made out.
Yeah.
So I think that is always a threshold question. And if you have that, then that can go up. But if you don't meet the threshold, then it's not appealable.
Okay. Okay, thank you. Mr. Mendes.
Might I just, by way of, I don't practice in the courts in Guyana, but I'm told that the Persad case, Mr. Ford, my co-counsel, just has one line that he would like to address to your lordships, and it's by way of a correction to something that was said. One line.
Well, one line.
Good afternoon, Your Honors. As far as I recall, the case cited by the Honorable Attorney General Ganga Prasad, I believe that decision was appealed by Mr. Nandalal, as he then was, and it was set aside on appeal by Justices Roxane George and Holder sitting in the full court. That was just my recollection. I didn't see him avert to that fact, Your Honor. Thank you very much.
Okay, Mr. Nandalal?
No, I didn't speak to the fact of whether it was appeal or not.
Yeah.
I just relied on Justice Chang's pronouncement on it.
Yeah. Okay, but it is correct what was said.
Yes.
Okay, thank you. Mr. Mendes.
Very much, Your Honor. Just a couple quick points. My learned friend, Mr. Jeremy, said that that it was argued on behalf of his client in the Court of Appeal that this case fell under Article 163(3)(a) as being analogous to a refusal of leave. I have no recollection of that argument being made. It's not in the written submissions, and I have no recollection of it being made orally. And you will have noticed that an argument along those lines was not dealt with by the Court of Appeal. My recollection is that the argument was that the dismissal of the petition, although one of the questions in Article 163(1) was not answered directly, was nevertheless tantamount to a determination of those questions. That was the argument that was made. It was not located in Article 163(3)(a) at all. But to the extent that this court is entertaining that argument, I've already made my submission on it. That this is a case that concerns what happened after proceedings had been initiated, and not concerning the refusal or grant of leave to initiate. The second point that I wanted to address very quickly again is the decision of the Privy Council in Arzu against Arthur.
Mr. Mendes, before you move on, you say you responded already, but Mr. Jeremy put an argument of analogy. So I would appreciate if you would at least so his argument is, as I understand it, that 163(3)(a) basically allows appeal where you don't move forward with a substantive hearing. And so he's albeit in the context of leave. So he says, therefore, by analogy, if you have, as in this case, the striking of a petition on the basis that it is a nullity, which he says is what the Chief Justice did, then by analogy, it is therefore analogous to dismissal of proceedings as contemplated in 3A. So you said you responded to it, but I don't think you heard that argument or responded to that. So, yeah.
Well, because I suppose I didn't respond directly to it because that argument does not work in Mr. Jeremy's favor. If it is correct to say that the decision in this case to dismiss on the basis that you haven't complied with the act is analogous to a decision to refuse leave, then that supports our case, because the legislature, the framers of the Constitution, decided to make appealable only one of those types of cases, which is the refusal of leave, and it did not make appealable the analogous type of case where you get dismissal after leave has been granted on the ground that you haven't complied with the procedural provisions. So I say I address the question whether it falls within the terms of 163.3a. I won't repeat what I said, but the argument that it is analogous does not work for Mr. Jeremy. It works against him, because it then reveals the intention that we have pointed out, that the framers of the Constitution have identified one type of decision of that category and no other. It has left out the analogous ones, and therefore it is implicit, therefore, that no appeal on those analogous types of decision was intended under Article 63.3.
Thank you.
Just briefly on the case of Azu against Arthurs, I thought my learned friend was citing it to you in support of the proposition that that the order in this case was a final order. That case was a decision on an appeal, dealing with an appeal against the High Court judge's decision on a procedural matter. But the Privy Council was dealing with a situation, with a provision that says the decisions of the High Court are final. And the argument that was being made there was that the finality clause applied only where you made a decision on its merits and not when you made a decision on a procedural matter. And the Privy Council said that when the High Court was exercising its electoral jurisdiction, it had the inherent power to dismiss cases, and that fell within the decisions that was covered by the finality clause. As a matter of fact, you will see at page 5050 of the electronic record, at letter G, the Privy Council says, the fact that no evidence has been heard does not affect the general principle. The court in the present case did not refuse jurisdiction. It decided in its particular jurisdiction that the petitions were defective. As a result, the petitions were dismissed. A dismissal based on a procedural matter is nonetheless a decision in an election petition, even where the matter has not proceeded to the hearing of evidence. And respectfully, that decision cuts across my learned friend's submission on section 42, because that decision, consistent with this court's decision in Coffey, says that when the court is exercising its power to strike out a petition, it is still exercising its jurisdiction as the special election court. So we're not taken outside of the regime. The last point that I wish to make is that my learned friend, well, quite apart from now trying to locate his case for the first time under Article 163.3a, locates his case under Section 6.2a of the Court of Appeal Act, and he accepts that he must therefore establish that the decision in this case is a final decision, or the order that is made is a final order. But he does not make any submission to you as to why the principles that this court accepted in Coffey does not apply to the determination of what a final order. This court determined that the application test is a test to be applied, all of the reasons that you have given. But my learned friend has not said to you why that Coffey principle does not apply to this case. That's all I wish to say in reply. Thank you very much, Your Honor.
Thank you very much. Counsel, we thank you for your arguments. We will have to consider them, of course. And as soon as we are ready to give a decision, we will do so. So you will be notified when that is the case. So thank you very much. Madam Deputy Registrar, can we close off?
Yes, we can, Justice Witt. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnetley. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to our staff here at the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.